Marty Giacomo and Giancarlo Pesci from the state.
Morning, Honor. Tom Erickson and Tom Pittar for John Valerio from this trip.
Okay. We have a juror that's apparently got caught in traffic, which was Mr. Giacomo, confirmed really did exist. And so, anything we need to talk about before we get started this morning?
Yes.
Yes, Your Honor. There are a few things.
These are all the transcripts good. Ready to issue the transcripts from the full order and the motion. And obviously,
So, Your Honor, we are renewing our objection to hearsay testimony being introduced through these transcripts. One of the important things that was done prior to
Chose for those two witnesses to seek an exception to the hearsay rule. And thus, I can't answer that question. I can tell you that the law is absolutely 100% clear. And it might have been, to be honest with you, Mr. Cuomo had never done one of these hearings before. A penalty redo after a very long period of time. Mr. Pesci and I have done a couple ourselves, and we've always just admitted the transcripts. And so I don't know if Mr. Cuomo just didn't think it through and say to himself, wait, hearsay is admissible. There's no legal basis to exclude the transcripts from the trial. In fact, while I changed the instruction in this particular case, the standard instruction given to a jury is you're entitled to consider the guilt and evidence and instructions as well as the penalty, evidence, and instructions. And so theoretically, all this testimony is already in for this proceeding. We are just not going to take the time to read every single witness. We put transcripts in of witnesses we either are not calling or haven't read in at this point.
I mean, Mr. Harris, I've looked at, the case law, and it does seem pretty clear and consistent that hearsay is admissible as long as I make a finding of general reliability, and the hearsay is something that is subject to rebuttal. So, I mean, the only thing and that reason I had asked, reason I thought possibly Mr. Cuomo was thinking is that, in doing my research on this issue, I found no cases, but I have found some commentary which, seems to suggest after Crawford maybe the aggravators should be proven by non-hearsay evidence. And so I knew he had gotten to one gentleman who would be 107, and then
Certainly that's true.
the coroner.
There's the dissent in Summers that suggests that you should differentiate between your aggravators versus your other matter evidence, and that Crawford may apply to the aggravators. So maybe Mr. Cuomo was just protecting his record, I'm not sure.
And I mean, I don't know when you made the decision not to bring in the victim of the second aggravating offense, which you said was currently fixated on that prior event. That probably wouldn't technically come in under the hearsay exception because you would be unavailable, but you did get in the certified copy of the judgment of conviction.
yeah, could I?
Go ahead.
Because we got this email yesterday of all these witnesses. This case has been, let me start, this case has been unique in that after many things have been litigated, all of a sudden in the middle of trial, we're having changes in opinions, i.e. the court order saying mutilation couldn't come in. This court is now during the middle of the trial reversed what was the law of the case for a number of years, and now said you're somehow letting mitigation in, the third
I
part.
would sort of read Judge Villani's order as essentially doing that.
He specifically said
you couldn't get mutilation in as a specific aggravator, but he seemed to indicate he was inclined to give depravity of mind as long as it included a definition of mutilation.
To me, that, with all due respect, is nonsensical interpretation. We file a motion, you can't have torture and mutilation, and the court rules you can't have torture and mutilation, and then you say, well, you call it depravity of mind, and now you call it torture and mutilation. I personally think that's nonsensical.
Well, I mean, I certainly appreciate you think that that's nonsensical, but I think Judge Villani had essentially gone down that route before I got here, and I actually restricted it more, or at least contemplated restricting it more in terms of cutting out torture, and we're going to need to talk a little bit here about the physical abuse issue that I asked everybody to take a glance at. I don't want to do that right now, but I mean, we're going to need to do that.
Yeah, we do have to do that, and we're prepared to argue that. But what our position is quite clear, and I'll state it again, and you alluded to the problem. First, let me do this. There was a case called United States versus Johnson, 378 Fed Sup 2nd 1051. And then there was that's a 2005 federal case. And then there's another case I have to settle with one, not the Supreme Court case, but a circuit case. But let me do for that. Let me just tell you what the issue is. And then Johnson, what Johnson did is went through an overview, if you will, of this issue. And the issue is the following. The normal case is that you have a trial, and the matter goes to the jury, and the jury has to, one, find that the person's guilty of first-degree murder, and the person finds also, did they find beyond a reasonable doubt that there were aggravators. After that is done, the jury then reconvenes, and then they make the determination of the selection of the penalty that they think is appropriate. There is, the court is aware, if you've done surveys of this, there's considerable academic interest, if you will, or there's law reviews, et cetera, on, in that case, what they call the trifurcation process. Because we have already gone through the guilt phase, i.e. we have a guilt verdict, which we have to live with at this point in time. We then go into the penalty phase. But by going into the penalty phase, we don't eliminate the distinction between eligibility and selection. Those are two different issues. Now, in the Summers case, which is out there, you had an issue where that issue was sort of talked about in the majority and the concurring opinion and dealing with eligibility and selection. In that, they never decided the issue. That is to say, they never had to deal now with the penalty issue and the merger of eligibility and selection by a different jury. Eligibility has now been moved into a different phase. Eligibility requires proof beyond a reasonable doubt, and it requires proof beyond a reasonable doubt by legal evidence. If you read the Johnson, they go through a whole history of it and talk about that issue. And then the hearsay aspect of it goes to the selectability. That is, what is the now, in the Summers case, the court held that some general instructions sort of set that out, but I couldn't find what that instruction was or what they were talking about, and I'm sure it was under the circumstances deficient, but nevertheless, the conviction went there. Our position is that on the eligibility phase, that in fact you must prove beyond a reasonable doubt with constitutionally permissible evidence, i.e. non-hearsay, for eligibility. That is, because you need that. You can't find something beyond a reasonable doubt with a hearsay standard. Hearsay in the penalty phase comes in, or hearsay comes in because the courts have held, and this is the line, as you're aware, that the judges, when they impose sentence, should be able to consider other things other than the facts of the trial. Dismissed cases, prior conduct, those sort of things. And they said that could be introduced through reliable hearsay. But no one, I think, has ever said that the court can find the aggravator beyond a reasonable doubt with hearsay. The problem has been more of a presentation problem, is that they've run together, and the jury is somehow, through instructions by the court, is supposed to somehow differentiate that. And of course, that's why we, in this case, and I think that's why we asked for this hearing to be bifurcated. That is, that we have the eligibility phase where the government is required to prove by legal evidence, I mean not hearsay. Okay, so that's the definition.
I know what you mean.
And the selection phase, then you can use the hearsay under 175.5223, which is that little section that talks about. But I mean, let's not lose sight of the fact of where we're at. That the line of the hearsay is, the genesis is the judge can consider things. But now, think of something you're aware of, course, when you had the Apprendi problem came in. And the Apprendi was, well, wait a minute, juries have to find, and they had to find beyond a reasonable doubt these things happen before you could enhance punishment. And so that's really what it is that we are saying and what we meant. The fact that hearsay is allowed in the hearing, and the court, I won't say illegally, but improperly or confusingly merges the eligibility phase and the selection phase into one, with evidence coming in for one purpose and not another, that it becomes a very confusing sort of mass. But that hearsay 175.5223 doesn't eliminate the issue of the burden of the state to prove the aggravator beyond a reasonable doubt. And so that's one of the issues we get in. We're proposing a solution as soon as that will come in, depending on who the first testimony is. But that is clearly our position. There is a requirement on the aggravator that you must prove it by legal evidence. And quite truthfully, if you look at it that way, that's what Mr. Cuomo was doing. For that information that was going to aggravate it, then he was going through the proper rules. Now, I have to say, when I was talking about the changing, and I do think it's a change. We have an order that says you can't use mutilation, but now they really can, we're going to give an instruction in mutilation, that is a problem. But what they've done is they're saying, oh, that must have been a different district attorney's office. That must have been a different state. They filed the motion. We go and we have a hearing. Judge Villani restricts a little of Hollander. We concede and let, what's his name, Hendrickson in. And then they say that if they're going to do any others, they'll do it by formal notice and motion. And now these prosecutors come in and say, well, forget it. Forget we did that. Forget we had those hearings. Forget we were the moving party to do this. And just let it go. You know, that actually is, you know, not the way we should run a circus. So I have a problem now where prosecutors come in and disavow, as they have during the course of this, prior rulings and also prior motions by them. And I think if you read the Johnson case on that, it was a pretty good explanation of all these things that are going around in the area of this. But clearly, I would like at least a ruling one way or the other. If the court is saying that they do not have to prove aggravators beyond a reasonable doubt, and that they can impute hearsay to prove aggravators, if that is in fact the court's position, I'd like you to articulate. I think it's wrong. And if it's not the court's position, I'd like you to articulate it that is not the court's position. But I think it has now been merged, is that sitting here now, Mr. Edwards and I have discussed this yesterday, we don't know what the court's position is anymore on the burden of proof of aggravators.
Well, the burden of proof is beyond a reasonable doubt. That's clear. That's set by statute and case law in that regard. The issue is the evidence that can be used to prove the aggravators. And you know, the case law isn't clear on that point. But I tend to look at, in this instance, that you know, the nature of the proof as to the aggravators is, one, essentially certified judgments of convictions as to violent crimes for both the two aggravators alleged. And then you're going to get in the testimony as unavailable witness testimony of the coroner in reference to what wounds were upon the body and the impact of those wounds upon the body as it would relate to depravity of mind. So I don't know if I need to necessarily make a definitive ruling at this point. I do think, though, that for purposes of this case, you know, the sufficient, you know, non-hearsay evidence is coming in, and I would be open to a jury instruction limiting the jury as to what evidence they could consider in order to determine whether an aggravator has been proven beyond a reasonable doubt. So, I mean, that's sort of where I'm at this point in time. But in terms of the remainder of the information, I mean, what has been established by the conviction is the essential elements of the offense, first-degree murder, have been proven beyond a reasonable doubt. The stuff filling it in as to what went on with in regard to the different actions that occurred during the murder aren't critical to establishing the elements of the offense which is necessary to bring us to this point in time. So I don't see any problem with the introduction of hearsay as to that information, and so I'm inclined to allow the state to introduce the transcripts and to use the one detective to discuss, you know, certain aspects of the case, and you're in a position to, I find, you know, based upon the transcripts and the reports, you know, that there's sufficient basis to believe that they're reliable, and you're in a position to rebut those if you need to.
Well, and I appreciate it, and we have not, we're not making the objection that Dr. Hollander's testimony isn't that clearly would have to go to eligibility under whatever theory it is that we're proceeding under. But the court has, or at least the government has, or at least it's been out there, this does not fall within a summary testimony under Rule 1006 under the federal rule, which
Well, I mean, it's hearsay
is
testimony.
identical to our rule, but I forget what the Nevada.
No, I know, I mean, no, it's not a summary, but I mean, it's essentially, it's hearsay testimony, which is admissible.
But what's it, no, it has to be admissible for something, Judge. That's
It's
our.
admissible to fill in the general nature of the crime that occurred here, and so the jury can consider those additional factors beyond the essential elements of the offense, which have been found to be proven beyond a reasonable doubt.
I guess, that for example, a person comes in and testifies that I did this or this, that doesn't go to eligibility, that's already been determined. And unless it goes to the character of the defendant, it doesn't go to selection.
No, I think the underlying nature of the crime is relevant in terms of the defendant's background and something the jury can consider, and that can be established by, it doesn't just the fact that he committed an intentional, non-accidental murder, the nature of how he did it, and what they determine in terms of the course of the investigation, I think is something the jury is allowed to consider in terms of selectivity. I don't see anything that precludes them from considering those aspects and deciding what is a appropriate sentence in this case.
Right, I think 175.522 subsection 3 does, because that only allows hearsay, that limits the issue of hearsay.
All right, well.
What else we got? We're not done.
Okay, let's try to go quickly then.
Your Honor, another issue that we would object to the introduction of the photographs from the corpse taken prior to the autopsy. And last night I was able to pull up the prior decision from the Supreme Court in the 1989 decision in Mr. Valerio's case. And the court specifically addressed that issue. And if I may briefly quote from that decision and then add a little more to our argument. This is on page 2 of the decision filed September 6, 1989. And it's the order dismissing the appeal in Mr. Valerio's direct appeal. Valerio also cites as error the introduction of a series of gruesome photographs of the victim's corroded corpse taken prior to the autopsy. The photographs were introduced into evidence showed many of the more than 40 stab wounds that were inflicted upon the victim. Because the victim's body laid in a closed car and was not discovered until 10 days after the murder, there was a substantial amount of bloating, discoloration, and decay of the body. Valerio alleges the probative value of these photographs was substantially outweighed by the prejudice which they instilled in the jury against Valerio. Although we hold that due to the strength of the evidence against Valerio, the introduction of the photographs did not substantially prejudice him, we caution that careful consideration must be given before allowing such potentially inflammatory pictures to come before the jury. Here, the coroner testified regarding the location of the wounds and the cause of the death with the aid of a diagram. Therefore, the contested photographs were of questionable value in assisting the jury to understand the coroner's testimony. Furthermore, because the body was depicted in a condition which was considerably different from how the body appeared after the attack, in these circumstances, the introduction of the photographs not only ran the unnecessary risk of inflaming the jury, but they were of questionable relevancy.
Okay, let me just stop you there. What's the state planning to do?
My position is that particularly since we have an aggravator which are highly relevant to those photographs, there has been a number of cases. And in fact, the court, when admitting the photographs, excluded a couple of guilt and said, I'll let these in penalty. For example, the stab wound to the vagina, he excluded during the guilt phase because it wasn't relevant to cause or manner of death. That's what the Supreme Court's talking about. Relevancy as it relates to cause and manner of death, and they're maybe not as relevant to cause and manner of death. But as it relates to the aggravator in this particular case, the depravity of mind.
How quickly are you going to get to those this morning?
Fairly quickly. Do you want to see them now?
Yeah, let's see them.
Are those the four that were not admitted during trial?
Well, these are all of them, including the four that were either withdrawn or not admitted. That have,
6, 8, 9, 16.
These are 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, and 19. Do you have copies of these, Mr. Erickson?
We do. I'm sorry.
Do we have, do you know
Well, I've seen all of these.
it should start with that.
That's what mine starts with this 5.
I don't know, Linda just said something about 5. The first photograph is 5.
That was admitted in trial.
These are both the admitted and the 4 that were not admitted. In a guilt phase, because the court had said he was letting in the penalty.
Your Honor, again, in referencing the Supreme Court's prior decision, we strongly object to these as being more prejudicial than probative. They have the diagrams of where all these stab wounds were. They have the testimony, or will have the testimony from Hollander as to where the stab wounds were and the types of injuries caused by the stab wounds, showing the photographs of the body was found over 10 days after the death. Does not show the body in a condition as the court indicated at the time of the killing, and is highly inflammatory and prejudicial.
I mean, I guess that is sort of my concern, Mr. DiGiacomo, as I sit here and, you know, these are obviously grotesque pictures, but they're grotesque in the sense that the body's been decaying and sitting in a car for, I mean, they don't even look like the person who, the victim in this case, was the one photo that you flashed at the beginning of the...
But there's a lot you can tell from the wounds themselves, which goes directly to violence over and above that which is necessary for the killing. The fact that you can tell, without getting too much and allowing them too much into our case, you can tell that the victim is not moving in a number of those wounds because of the nature in which they are inflicted on her. There is no other testimony that is going to describe that. I mean, I'm assuming that a witness may describe that, but there's nothing better demonstrative of what was happening to Karen Blackwell at the time of this crime than those photographs. I would note that the court admitted all but the vaginal one, the stab to the back because the medical examiner couldn't orient herself to it, and then I believe, I don't think that has the list in front of her, but if you look at these, and in my 20 years of doing this, and Mr. Pesci's as well, as long as the photos are not duplicative, if it demonstrates the injury to the body that is not shown in another photograph, it has been ruled to be admissible. That's green, which I would note is post Valerio, in which courts routinely go through and say, okay, of all the autopsy photographs in this case, how many are the fewest number you can use where you can show every single injury to the body
that's
of
what
the victim?
I'm looking at right now.
And I've gone through those, Judge. And the medical examiner says this is too. The ones to the chest, the neck.
Which are the 4 that were excluded at trial?
There is the vaginal one, I know for sure, and the back, and I'll have to look at the other features. Let's see the.
Give me the numbers of the ones that were excluded at trial.
Well, he's looking at those. If I can address some of the arguments that he is making, that being that these show the extent of the nature of the injuries, things of that argument. From the testimony that's going to be presented through Hollander, I'm going to read from page 200 of her trial testimony. The question was asked by the prosecutor, and what was the cause of death, please? Answer, the cause of death was multiple stab wounds of the neck, the chest, the back. Question, Could any of these alone, or did all of them together cause the death? Answer, all of them together caused the death, which we'll be arguing in relation to the mutilation, depravity of mind instruction or aggravator here soon. But then on 2 pages after that, page 202, she was asked, question, what kind of force would it take to thrust a knife into the body in the manner which was done here? Answer, the stab wounds were through soft tissue, skin, and soft tissue.
These are the 4 that were taken out?
Those are the 4 that the court didn't allow in.
Okay, where's the remainder of them so I can scroll? Sorry.
And I would note that the one with the blunt trauma to the head wasn't allowed in because it wasn't relevant to cause and manner of death. Versus, and the one stabbed in the vagina was not let in. And I think what she ruled as to what the court ruled as to the neck and the left ear. My recollection is that he ruled those 2 duplicative. And so if the court, if you look at the one with the left head, you can actually sort of see the wound to the left neck. So if the court were to rule that was duplicative, that would be consistent with what the court ruled previously. I would also note that Mr. Erickson, I would say he didn't misquote it, he misconstrued what Ina Hollander was saying, and I think Mr. Pesci has the site that explains it.
And the cord was found around her neck?
Yes, that's correct. The orange zip tie was around her neck, not tight.
What am I getting with number 19?
Let me see which one it is. Sure, show it up. There's a defensive wound to her left hand according to the medical examiner.
Does the medical examiner use this in her testimony?
She does.
Go ahead,
I'm not
Mr.
sure if
Erickson.
I'll finish this quote from the corner. The question was, what kind of force would it take to thrust a knife into the body in the manner in which it was done here? Answer, the stab wounds were through soft tissue, skin, and soft tissue. They were not through bone, so that force would be moderate, but not excessive. The evidence of the number of stab wounds, where those stab wounds were, all of that comes in, as well as the diagram that they have that shows throughout the body where they were. Introducing the decayed body that was found 10 days later as a Supreme Court caution is highly inflammatory, and given the change in the body is not representative of this attack. And we think it is clearly more prejudicial than probative, and we would request that all of those be precluded from introduction.
So Judge, let's follow that logic. Let's assume that I'm a good murderer and I hide the body well, to the point that when it's found there's so much decomposition, it's so prejudiced now, this evidence not coming in. And I would point this court to subsequent Supreme Court case law on this issue that Linda's actually aware of, because in front of Judge Mosley, Brookie West was tried when a woman was stuffed in a trash can and she literally oozed out. That was what was left of her. That testimony came in. Those photographs came in. They were extremely gruesome, but they had to be introduced in order to show what had happened. Now, that was guilt phase. The Nevada Supreme Court said in Brookie West that could come in guilt. We are well beyond that, and it's so important because we're talking about depravity of mind. And what counsel just cited to on section page 200 is kind of a little bit off kilter here, because some of the injuries she's talking about are the ones that cause death. She specifies, she being the coroner, Hollander, whose testimony is going to be read in. She says the cause of death was multiple stab wounds of the neck, the chest, and the back. If you go back a page and you go forward a page, she specifies that the injuries to her head did not cause death. The injuries to the back of her neck did not cause death. So that's 8 to the head, 8 to the back of the neck, and then the ones that are on her abdomen and her vagina, and they didn't cause death. On her defensive wound, on the one you just saw in her hand and her shoulder. We have to show that this individual did damage beyond the killing itself. This is the very evidence of the depravity of mind that they're now trying to exclude. We have to get this in, Judge. We have to be able to show that these other injuries are beyond the killing itself. And you don't get to hide from your handiwork when you're a murderer.
I don't need any more. Why did the judge exclude the vaginal?
At the time, he says it's not probative to the cause of death, but I will let it in penalty. I mean,
Okay, there
obviously,
wasn't anything I'm missing here in the picture.
no, there's a vaginal one that, I believe there's a, you can see one of the abdomen, one up higher on, if that's the right vaginal one. But it's the vaginal shot, and the reason he excluded was.
Looking at it, that's exhibit number 16.
Correct.
Okay, all right. Anything else briefly by anybody?
No, Your
Okay. I am concerned, the state hasn't not, the testimony of the doctor or the coroner does not convey the brutality of the wounds that are involved in this instance. The corpse is decomposed and bloated, and that does concern the court in that regard, but actually the pictures are fairly isolated to where I don't find that to be an overwhelming issue. I do think it is relevant to see where the wounds were, how they were. That's something that just cannot be conveyed by testimony and charts. Looking at the wounds to the head on exhibit number 7, 7, and then to the neck on 9 and 10, and then the breasts on 12, 13, and the abdomen on 14, and 16. What's 15?
Let me see, 15.
They will be-
It's the knife wound to the back.
Okay.
And that's the only photograph of the knife. That's the only photograph of her back, period, other than the back of her neck.
Okay.
And in fact, that is a mortal wound.
And then 17, wound of the arm, 18, and then 18 and 19. We have defensive wounds on the hand. Five shows the cord around her neck. And then 8 is a picture of the wound in the ear and the back of the neck. I mean, I'm not suggesting they aren't gruesome, but they're isolated enough. I do think it conveys something significant for the jury to consider during the course of the decision as to what is appropriate sentence. I find that 11, which is wound to the back of the neck, is shown by the one picture I just mentioned. And I'll just have to say I don't see, whereas the other ones are fairly isolated in terms of minimizing the impact of the decomposition, I'm concerned with picture number 6. So I tend to, at this point, favor excluding pictures number 11 and picture number 6. I want to get going, so.
My concern with number 6, judges, is that of all of the wounds, the medical examiner says that the injury to number 6 is a laceration caused by blunt force trauma. It is definitely not done by a knife. And that wound is highly relevant because it has absolutely nothing to do with the cause and manner of death. And in fact, it is the wound that that incapacitates her initially, most likely,
Well,
and then the stab wounds that occur. But
Well,
No, Judge, time out.
we should be entitled to
We're not-
establish,
I understand, but, you know, we hear talking about cases that aren't there. They're talking, and now he's rendering medical opinion that is not in there, that this must have been a disabling wound, that there's nothing in there on it. As a matter of fact,
it's exactly what the medical examiner said, that when she was hit in the head, she
All right,
would
well,
be maybe unconscious.
Maybe,
you wanna
but
get into
not what
number
you're saying.
6, you've gotta hear, you're gonna need to redact it down substantially beyond this. So I'm not gonna allow this in. I don't see any reason to, beyond what's necessary there for the wound, I'm not gonna allow it in. So if you wanna do that, or you wanna cut it right now in terms of the top order, I'll
If
let
the
you
court,
do that.
I'll give the court the scissors, you tell me where you want to cut it, and we'll cut it. We have to put a new tag on it, but I've already cut it.
Actually, yeah. All right. That'll be the ruling of the court. All right, anything else before we get started? I had asked everybody to give me anything by noon yesterday, so I'm not particularly thrilled we're sitting here with all these new issues here today.
The only question I have, Judge, is that any 11's excluded?
Yes.
Okay, so 11's excluded, and just the remainder of 6 will mark as 6A.
Okay,
For purposes of the record, and then 6 will.
all right. Anything else, Mr. Erickson?
No, Your Honor.
All right. Anything else from the state?
Nope, I just have to reorder my photographs, and we're ready to go, Judge.
All right, let's get going.
Ready, Your Honor?
Yep.
All right, you're hearing.
All right, let the record reflect the presence of the attorneys, both sides, presence of the defendant, the parties stipulate the presence of the jury panel.
Yes, sir.
Yes, Your Honor.
Okay, very good. All right. Let's go ahead and again formally call State of Nevada versus John Valerio, case number C077268. Counsel, go ahead and note your names for the record.
Mark DiGiacomo and Giancarlo Pesci for the state.
Good morning, Your Honor. Tom Erickson and Tom Picaro with Mr. Valerio.
All right, ladies and gentlemen, it's good to see everybody on today, a nice day. I guess from what I understand, it was pretty cloudy during the eclipse here in the valley yesterday. I hope somebody, at least the solar classes weren't too expensive, so not a major expenditure in that regard. It's good to see everyone. Thank you for getting here in fairly timely fashion today. I apologize for getting started late. We'll get started right away and make it full use of the day that we have for us. The state will call us next witness.
There's two interpreters.
Oh, that's right, we have the interpreter going. That's, I didn't see her over here today because apparently we've got our equipment going. All right, let's get, again, ma'am, what's your name?
Mildred Arquero.
Okay, all right. We swore her in the other day, right? Okay, all right. You appreciate you're still under the same oath as the other day when you translated.
Yes, yeah.
All right, very good. All right, and Ms. Smith, can you, are the headphones working all right with you? All right, let's make sure they work okay before we get going.
I don't think it's working.
That's not what I want to hear, but I'm not shocked and amazed either. Because Marshall, can you help her with the?
I have no idea how it works.
I know,
It's
but
their equipment.
you probably have a better idea than anybody else. So.
They're talking to it.
Excuse me. Yeah, I can hear you.
It's on. Is it loud enough?
Yes.
Okay. No, it wasn't on. It was off.
Okay. All right. Well, that will cause a problem. So. We'll remedied one thing, so far so good. All right, let's try that again. The state can call its next witness, put on its next evidence.
They called Edgar Stubs.
All right, sir, come up to the witness stand. There's a couple of steps. We'll get to the top step. Please stay standing for just a second, and our clerk will swear you in. Over here.
You do solemnly swear the testimony you're about to give in this action should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please be seated. Please state your name and spell your first and last name for the record.
Edgar S. Stubbs, Edgar Stubs.
Go ahead.
Sir, what did you do for a living?
I was a police officer with the Las Vegas Metropolitan Police Department.
When did you hire on with Metro?
January 16th, 1980.
And when you started with Metro, where was your first assignment?
It was then called the South Substation, which was the southeast part of town.
Okay. And then kind of go through us your time with Metro, where you served.
Well, I worked for 33 years, and I stayed in uniform patrol for that length of time. And my career started at the South Substation, which was the south part of town. And I worked there for 7, 8 years, transferred up to the west side of town, which was called the West Substation, and worked there for a number of years, transferred back to different substations, all while staying in uniform patrol. And that's calls for service. That's the guys that drive the black and whites. And eventually going to Northwest, and I retired out of the McCarran Airport substation in April of 2013.
All right. I want to direct your attention specifically to 1986. What area were working then?
South, the southeast part of town.
All right. Now, did that area of command that you worked take into your area, Maryland Parkway?
Yes, it did.
Okay, and I want to direct your attention to September the 29th of 1986. Did you go to the 500 block of Maryland Parkway, which was known as the Camelot Apartments?
I believe it was the 5,000 block
I
of
apologize.
South Maryland Parkway, and that is the Camelot Apartments.
Tell us about how you were there, about what time it was, what was going on.
It was late afternoon, around 5 o'clock in the afternoon. I was on a patrol squad, so our primary function was handling calls for service. So in between those calls for service, in the downtime, I would cruise around different areas of my area of responsibility, make car stops, look for stolen vehicles, recover stolen vehicles. The 5,000 block of South Maryland Parkway Camelot Apartments is an area, apartment complex, where I had recovered stolen vehicles on prior occasions. So it was a spot that I would cruise through occasionally, not every day, but occasionally, and I would run plates in that area. And that's the plate I first ran on, the vehicle in question.
A vehicle in question, did you in fact see a car that grabbed your attention, a Pontiac Trans Am?
I did.
And of course, what's showing?
Go ahead.
Showing you it's been marked as state's proposed exhibit 1 has been
Mr.
shown.
Erickson, you have this, I assume.
Yes, Your Honor, please.
Been shown to defense counsel.
Yes.
Do you recognize that?
I do.
Is that a photograph of the car that caught your attention that day?
It is.
Move the admission to state's 1, Your Honor.
We not previously made this. All right, go ahead. Any objection to stage 1?
No, Your Honor.
All right, stage 1 will be amended.
Thank you, Your Honor. There's going to be a TV screen to your left that has that photograph. When you first came into contact with that photograph, or I'm sorry, the car in the photograph, did you have time to really investigate, or were you called out to another call service?
No, I noticed the car initially at around 5 o'clock that afternoon. It stuck out just because of where it was parked in the parking lot. It was separate from most of the other cars in that apartment complex. It was parked in the aisle that was the furthest west, and the apartments are to the east of that. And it was dirty. It looked like it had been sitting there for at least a few days, and those were the type of things I look for when I'm trying to look for a stolen vehicle. It may be that I can recover.
So those things came to your attention?
They did.
Okay. At some point, were you called to another call service?
I was. Several calls for service. It got busy after that. It generally does in the early part of the evening. So I was handling calls, call to call for several hours after that.
Eventually, were you able to make your way back to this particular car?
I did, because while I was initially there, I ran it and there was a hit on the plate for a possibly missing person that may have been involved in foul play, so I wanted to get back to that vehicle to see it. I didn't have that information when I first saw the vehicle. I got that several hours later, so as soon as I got that information, then I went back to the car to see if I could locate the registered owner of that vehicle.
This was 1986, correct?
Yes, sir.
Not as updated and automated as we are today?
Different now. Now, even before I retired, back in '86, you had to do individual queries on the computers in your vehicles. Nowadays, you put in a license plate or a name, and it just covers all of the different aspects of this system, the NCIC scope, even your driver's license. So I didn't have that benefit back then.
But you did eventually get that information about a missing persons report tied to this vehicle, and you made your way back to the vehicle.
Yes, sir.
All right. When you went back to the vehicle, what did you do?
When I went back to the vehicle, I watched it for a few minutes. I attempted to contact the manager's office of the Camelot Apartments to see if the registered owner, the name on the registered owner was happened to be a resident there. It was closed, so I went back to my car. I had parked my car behind the vehicle. I didn't want it leaving when I was away from my vehicle to contact the manager. And I looked inside the vehicle.
Okay. When you were describing all this, were you working by yourself?
I was.
Okay. And you said you looked in the vehicle. Did you approach it? Did you get close to it? Tell us about that.
I walked up to the vehicle. It was later in the evening, 10 or 11 o'clock. I can't remember, but it was dark. And so I had my flashlight, and I initially walked up to the driver's left side of the vehicle to peer in. The front seats were empty. The back seat had a pile of blankets in it, and and I could see that from my flashlight when I swung my flashlight in the vehicle.
Okay. And when you looked in with those pile of blankets, did anything else catch your attention?
It did. When I was looking in the back seat, I could see protruding from underneath one of the blankets was a white high-heel women's shoe, and what appeared to be the ankle of a woman was there as well.
Okay. And now that's visually what you were able to assess. Did you also smell anything when you were up near that vehicle?
When I saw the shoe and the foot protruding from underneath the blanket, I moved closer to the car, up to the jam. There was also a little bit of blood around that same area of the blanket where the foot was protruding out. So that made me a little bit more concerned. As I got up close to the jam of the car, I smelled and I could detect an odor coming from the vehicle.
Now you said a moment ago you started in 1980. The events you're describing are 1986. Between 80 and 86, had you ever come upon a dead body?
Yes, I have.
In the course of your duty positions?
Yes.
Did you ever come upon a decomposing body?
Yes, I have.
Were you familiar with the smell of decomposition?
I was.
Did that smell appear to be what you smelled at this vehicle?
It did.
Based on seeing blood, a foot, and smelling that decomposition, what did you do?
At that point, I backed off and I got on my radio and I notified my supervisor at the time, the sergeant working, and I also contacted general assignment detectives, which was our protocol at that time when these type of situations arose.
And then did those other individuals respond to the scene?
They did, along with an ID officer who also I requested ID. They all responded. I was basically on scene from that point on just to secure the scene and make sure that the area was secure and not contaminated by anybody else coming in.
When you say ID, are those the criminalists?
The criminalistics bureau, yeah, ID officers.
Are those the people
CSAs.
that took the photograph that we're looking at?
Yes, sir.
Okay. No further questions.
All right, cross-examination.
Yep.
Stubbs, how are you?
I'm well, sir.
Retired?
I am.
Lucky you.
Thank you.
I take it that you had to review items to come in and testify today?
I reviewed my old reports and my previous testimony transcript.
All right, so you reviewed your, the report that you filed,
Yes, sir.
and when did you do that?
It was the same evening I dictated that officer's report, so it would have been the 29th of September.
No, I said, when did you review it for testimony today?
Oh, I reviewed it yesterday and I also reviewed it this morning.
Yesterday and this morning.
Yes, sir.
All right, so you know what you put in your report then?
Yes, sir.
And actually, your testimony here today has left out a major portion of that report, hasn't it?
I'm not sure, sir.
Well, let me start. You said that you were driving around the parking lot
Yes,
and you noticed a vehicle, a late model blue Pontiac, bearing a license plate, right?
yes, sir.
And then you said you took an opportunity to run the plate for the registered owner,
Yes, sir.
right?
Yes, sir.
And when you ran the plate for the registered owner, you ran it through Scope.
Correct.
Now, Scope is the name that we call the the computer that's in your squad car, right? That pulls up the information.
Yeah, Scope gives us the local warrants and wants on a individual.
So you didn't, at the time, that when you ran the Scope up, you found out information, right?
I did.
And that was the thing that directed your attention to this vehicle once you ran it up, right?
Initially, it does.
And what that information was, that the owner of this vehicle was a Karen Blackwell,
Correct.
and that she was wanted
Objection, Rob.
for armed,
Hold on, let's go to sidebar.
Now, Officer Stubbs, you didn't mention that in your direct testimony that there was warrants outstanding, did you?
Not this morning.
No, but you said you read this in your report just this morning,
Yes, sir.
right? And when you came up here now, what you did is you told this jury exactly what you did, and now we're finding out that there was other stuff that was involved with this, right?
I had other knowledge.
Right. Well, we're talking about the knowledge that you had that night.
That's correct.
Right, we're talking about why you did things that night, right? And these warrants were out there, there was more than one, wasn't there?
I believe there was two.
Yes. And on these warrants, what you did is after you determined there were warrants, what you did is you then moved your patrol vehicle and started observing the car, right?
Initially, I observed the car for a few minutes until I got calls for service and I had to be pulled, I got pulled off.
Well, isn't it true that what you did is that you thought that the registered owner of the car may be living in the Camelot's apartments,
Yes, sir.
and that was for the warrants, right? And that the car was parked there.
Jack, I've asked the witness to have the opportunity to answer the question.
Oh,
Well, I think, no, I mean, you can ask him yes or no questions, go ahead. I'll overrule.
You didn't get to answer.
And it said
I
yes.
think he said yes.
Well, let me start over.
I mean, go ahead, Mr.
Okay, let me go slow. You thought that the registered owner might be living in the Camelot apartments, right?
yes, based on her vehicle being parked there.
And you thought that the person may have chose to lift the vehicle, right?
Yes,
And that you then wanted to go to the Camelot apartments to see if the person lived inside the apartments, right?
I didn't do that until later in the evening when I came upon additional information that she showed there was an asterisk or a note in scope showing that she was the missing person, subject of a missing person report, and that foul play made me suspect.
Okay, but
That's why I went to the manager's office at that point.
let's get before that,
Okay.
hours before that.
Sure.
Right, we're talking hours before this night, aren't we?
Yeah, 5 o'clock-ish.
Well, 5 o'clock is, and then you didn't go to the manager's apartment, I believe until sometime after 10 o'clock.
Correct.
So that's 5 hours.
Yes, sir.
That's more than half your shift, isn't it?
Yes.
Okay, so what we've got here then is, you see this automobile, you see it parked, you find out that the owner, Karen Blackwell, has 2 outstanding warrants, right?
Correct.
And then what you did is that you then set up in the vehicle, right?
Yes, sir.
And what you mean by set up of the vehicle, that meant that you moved your patrol car a distance from this so you could watch the car.
That's correct.
And that you did that for an appreciable period of time, correct?
I don't really recall how long it was. It could have been anywhere as few as 15 minutes to as many as 30, but it was, that was contingent on how busy it was and if I got a call for service. And that's what ultimately happened.
And then, well, remember, this starts at 5, right?
Yes, around
Okay.
5.
And you're telling us that sometime after 5, you don't remember how long, but you set up off the car in hopes that the owner would return, right?
Correct.
And then, this was well before you found out she was a missing person, wasn't it?
It was before.
Yes.
I found that out during the course of the shift after I left.
Right, well, you found it out after the course of the shift, some 5 hours later.
5 hours later is when I finally got back to the location. I may have gotten that information earlier in the shift, but calls for service kept me busy, and I wasn't able to return immediately.
That's not what you said in your report 30 years ago, is it?
I'd have to review my report to know for sure, sir.
May I approach?
So what, is it just a one-page report?
That's a 2-page,
Show the prosecution what you're going to be showing.
I know what it is, Your Honor.
Okay, all right. I want to make sure we're all on the same page. Okay, go ahead.
so read the top sentence in the 3rd paragraph to yourself.
That's my point.
So, where you just said that you found that out before you came back at 10 o'clock, that's not correct, was it? According to your report.
I guess it's not correct. It was all in the same sphere of time during the shift and in between calls for service.
Well, that's not what you said, was it?
Okay, that's what I dictated back then, sir.
Yeah, well, when you dictated it 31 years ago, I think your memory was a little better than it is today.
Probably.
Even though you read this report just this morning,
Yes, sir.
and that you didn't mention that on direct examination,
Yeah, I must
and you didn't mention anything about the wants on direct examination,
That wasn't
and
asked.
you didn't mention anything about the 5-hour delay on direct examination, right?
I was answering the questions that were asked me, sir.
I understand, but those didn't put that information in there, did it?
No.
They left that 5 hours out. If we just listen to what you said in direct examination, we wouldn't know that you had spent 5 hours on this before you even found out it was a missing person was up there, right? The 5 hours, all you believed was that this person was wanted, right?
Correct, yes.
And that's why you were looking for her.
That's why, yes, that's why my initial response to the car was.
So we now know that, not because that's what you had said in direct examination, but because we were lucky enough to have read your report. Right?
If you say so, sir.
I have no further. Thank you.
Okay, redirect.
Well, now we've talked about 5 hours and what we know and what we don't know. Let's go over some of those facts and what we do know. At the 5-hour mark, at the beginning of this interaction with the car, she was dead, wasn't she?
I believe she was, yeah.
Based on the decomposition that you smelled, did she magically become decomposition in 5 hours?
No, I don't believe so.
So the 5 hours later, at 10 o'clock when you ran it or you didn't run it, it didn't change the fact that she was already dead.
No,
Nothing in your report changes what you saw and how you discovered that body.
no, sir.
Thank you very much.
Cross.
Yeah, just, what it is you just left out an appreciable period of time of what you did, right?
It's actually on the scope of the redirect.
No, I'll overrule.
Right?
Rephrase that, or ask me again?
I said, what we're saying is that you came up and said you showed up in an apartment, you saw a car, you ran it for you saw it was wanted, you left, and then you came back. You left all this out about that you were setting up in the car for a period of time because the person was wanted, right?
Objection, asked and answered.
This is recross and I'll overrule.
Right?
Well, yeah, that was my initial response to the car, was that there was a warrant, and I sent out on it for, I can't remember how long, could have been a very short period of time until I was called off on a call for
Could have been a
service.
long period of time.
No, it's too busy, calls for service, or it was way too busy that evening to.
Well, you know, I mean, guess the thing is now you're guessing, aren't you?
No, I'm not guessing.
You told me you didn't know how long it was.
But it could have been, it wasn't for a long period of time, it could have been anywhere from 15 to 30 minutes.
Okay.
I think that's what I tested.
All right, 30 minutes.
Okay,
All right, but none of that came out, and then you left.
yes,
And so it's not until 5 hours later you find out a person is missing.
correct.
Redirect.
No, thank you.
All right. Ladies and gentlemen, as I mentioned earlier, you can ask questions. If you wish, if anybody wishes to ask a question of this witness, go ahead and write it on a clean sheet of paper on your notepad. The question should be addressed to the witness, not to the attorneys or to the board. After you've completed writing your question, raise your hand, and the marshal will pick that question up. I'll go back and meet with counsel at sidebar, and we'll discuss whether or not the question is appropriate to ask. If I determine the question is appropriate to ask, I'll ask the question. You shouldn't put any special weight on any questions asked by any of your colleagues or yourself, and you should not put any special weight if the court should decide not to read your question. Is there any member of the jury who has a question for this witness? Okay, not seeing any hands. Once. Thank you very much. You're excused, sir. State may put on its next evidence.
James Vaccaro.
Sir, if you come on up to the witness stand, there's a couple steps up here. Stay standing when you get to the top, and my clerk will swear you in.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Thank you.
Please state your name and spell your first and last name for the record.
My name is James Charles Vaccaro, V-A-C-C-A-R-O.
Go ahead.
Sir, are you currently employed?
No, I kind of do handyman work and automotive work for my family, unemployed job though, no pay.
Are you retired?
Yes.
What'd you retire from?
The Las Vegas Metropolitan Police Department
When did you join on with Metro?
in September of 1977.
If you could sort of go through, give us sort of the course of your career.
I went into the police academy in 1977 and graduated in January of 1978. I became a patrol officer and was a patrol officer until 1980 when I tested for a position as a SWAT officer. And I got that position and was there for 4 years. In 1984, I tested for a position as a narcotics detective, and then I got that position, and I was in narcotics from 1984 till almost 1994, 10 years. Then in 1994, I became a homicide detective after testing, and I remained there until I left the police department. I retired in 2007 after 30 plus years, so it was 14 years of homicide.
During your time in homicide, how many cases do you think you investigated?
I was involved in hundreds of cases, During that time, I never kept track of the exact number. I know I was on in excess of 400 to 500 death scenes during the course of my career, but hundreds of investigations were assigned to me during that 14-year period.
Now, I'm going to direct your attention back to sort of 1986.
Yes, sir.
In September and October of 1986, were you what we call TDY to a particular assignment?
I was.
What does TDY mean?
A temporary duty assignment. I was, at that time, as I said, in 1986, I was a narcotics detective. And I temporarily, for 3 months, went to our general assignment detail, which are detectives that are first responders to major crimes. And they evaluate the situation and then call in the specific detectives, such as a robbery or a homicide detective, depending upon the type of crime that you first respond to.
In September and October of 1986, as part of your temporary assignment to general assignment, did you have involvement in the investigation and ultimate arrest of John Valerio?
Yes, I did.
You see Mr. Valerio here in court today.
Yes, I do. He's seated to the far left of the table I'm facing, next to Mr. Patero.
May the record reflect the identification of the defendant.
Record will so reflect.
Now, you weren't in homicide at this point in time, that's correct?
That's correct.
Do you know who the lead homicide detective was in this particular case?
I do. There are two detectives that are familiar to me. One's name is Tom Dillard, and the other one's name is Bob Leonard.
When you joined homicide, were either one of them still there?
They were still.
And so you've worked with them?
Yes.
Now, were you requested by me to sort of review a variety of information in this particular case in order to sort of summarize the investigation into the murder of Karen Blackwell?
Yes, I was.
Let's talk about what you had at your disposal to look at. Did you have the police reports associated with the Karen Blackwell investigation?
Yes.
And that investigation, did it have what they called a DR number back then?
Yes, it did.
What's a DR number?
In those days, it was called a DR number for daily report. It was a number that started with the year that we were currently working in, and then numerically, the events of that day would trail on. So if the first call of the day would be 0001, and so on and so forth, and then each day would reset during that time period.
And in this particular case, was there a unique identifying event number so you knew the reports you're reading were associated with the Karen Blackwell?
Yes.
Did you also have an opportunity to review all the photographs taken under the same DR number, both at autopsy, the various crime scenes, the crime lab, and everywhere else?
Yes, I have.
Were you all provided trial transcripts and other transcripts associated with the prosecution of Mr. Valerio in 1988?
Yes, I was.
And did you also receive information as to a prior robbery committed by Mr. Valerio in 1983 and a battery with a deadly committed by Mr. Valerio in 1986?
Yes, I'm aware of both of those.
And finally, were you also, did you find within the electronic file provided to you photographs of Karen Blackwell and Summer Blackwell and one of Roger Blackwell in real life?
Yes.
Did you review all those items?
Yes, I did.
And do you feel comfortable sort of describing to us in a summary fashion the nature of the case, the investigation, and the arrest of Mr. Valerio?
Yes, I can do that.
Your Honor, may we have a sidebar?
Okay. All right, ladies and gentlemen, we're going to take a quick break this morning, hopefully a quick break. Everyone can stretch for a second and go to the restroom if you need to. And while you're out on the break, do not talk to each other about the case or about anyone that has anything to do with it. Do not talk with anyone else about this case or about anyone that has anything to do with it. Do not let anyone talk to you about the case or about anyone that has anything to do with it. If someone should try to talk to you, please report to me immediately by contacting the marshal. Do not read any news stories or articles or listen to any radio or television reports about the case or about anyone that has anything to do with it. Do not visit the scene of any events mentioned during the case or undertake any investigation, experimentation, or research on your own. This would include use of social media to in any way discuss the case, or the use of the internet or other resource materials to do any investigation or research. Do not begin to form or express any opinion on any subject connected with this case until it's finally submitted to you. Thank you very much. We'll see you back as soon as we get done with your restroom break and we can get organized.
All right, directly.
Either send it to her or give me a citation. I can run back and get copies made for everybody.
Yeah, it's,
I'm giving 122 Nevada 1326. There is a companion case that came out the exact same day, which addresses this issue, and then it's also been addressed a number of times afterwards. Let me give you the companion case. The one that came out later is Burnside, also my case, 352 P3rd 627, in which they specifically say, to the extent
P3rd, what, I'm sorry?
P3rd 627, to the extent that Burnside argues the state presented hearsay evidence to support an aggravated circumstance, our decision in Summers v. State allows for the omission of hearsay in a capital penalty hearing. So they address that exact issue both in Summers, in the dissent and concurrence of Summers, in Burnside, and there's actually a couple more cases where they addressed this issue repeatedly and said that's not the law in the state of Nevada.
now, let me just,
All right, do you have Burnside?
I can give you the site.
You gave me,
no.
it's 352,
No, I know the
P3rd
case.
627.
The concurrent
Right.
case with Summers, though, that came out the same day, is Thomas, and it's 122 Nevada 1361, where they reference back to Summers for this exact same issue. This is the most settled law in the state of Nevada.
Your
Let me
Honor,
go.
let me just direct you where I would like you to,
Well, I'm gonna get it and bring it back out here, but go
oh,
ahead.
then we can talk about it?
Yeah, but go ahead and let me know.
All right, because actually, contrary to what the state is arguing, that the Supreme Court held the opposite, and it's what I said in there. And let me just read you the operative words.
Are we in Summers?
In Summers.
Okay.
And this was on the clear by instruction. If juries can perform an act of intellectual discrimination permitting consideration of prior bad act evidence for one purpose, but not for another, which is generally, we're talking about limiting instruction, we're talking about the normal 105 situation. It says they are most certainly intellectually capable of following a clear instruction directing that they must refrain, let me read this again, clear instruction directing they must refrain from considering testimonial hearsay in deciding a capital defendant's death eligibility, but that they may nevertheless consider such evidence in deciding whether to actually impose a death sentence on a defendant whom they have found eligible to receive it. That's exactly what we are saying, that there is the difference between eligibility and selection, as we've called it. The Supreme Court recognized it. In Summers, they said, well, we think now that the whatever the instruction is may have been clear. Then they reference to the 105 situation, the stock instruction. And in that, you ask for a limiting instruction. It's appropriate if you ask it. It's actually reversible error not to give a limiting instruction under those situations. But nonetheless, we asked for it. We gave you it. We would want it read. Even though the testimony itself is over our objection, we think the limiting instruction must be needed.
All right, let me
And
go
that's
through
what
it.
it says.
Let me go grab these cases. All right. So hearsay apparently seems to be admissible as to the aggravating, but it does seem, looking at your Thomas case, that you have three proper purposes for which the state may introduce evidence at capital hearing. One is to prove an enumerated aggravator. Two, to rebut specific mitigating evidence. Or to aid the jury in determining the appropriate sentence after any enumerating aggravating factors have been weighed against any mitigating circumstances. Evidence submitted for the third purpose is what we mean by other matter evidence and is not admissible for use of the jury in determining the existence of an aggravating circumstance or weighing against the mitigating circumstance. And it seems at this point his testimony is going to be going into Well, what?
Well, and that's why
Aggravating
there's
circumstance.
mutilation, depravity of mind. But the instruction is actually a set of instructions in the package I sent you. It's the evidence instruction. What they tell the jury is, in order to consider other matter evidence, you must first establish the nature of the aggravators, and then the aggravators outweigh the mitigators. Now, I would suggest to the court that the other matter evidence normally is not evidence associated directly with the crime, although at times it can. In Thomas, it was directly related to the guilt phase. They couldn't get a witness on guilt, so they put his hearsay statement in penalty. But I'm going to suggest to the court that they are sentencing this defendant for the crime that he committed, and I don't think this is other matter evidence, nor is it necessarily all aggravator evidence. Some of it obviously is aggravator evidence, and it's certainly not mitigation. This is sort of a unique experience because of the penalty hearing, as the jury has no idea what happened in the underlying case in this particular situation, and those aren't actually captured in those instructions. Other matter evidence is normally other character evidence of the defendant. This is what I would call under 175.552 as any other thing relevant to the determination of the sentence, which that's what I would say this testimony is I don't actually think it's any of those three, because it's something that normally you don't need to do in the penalty phase.
Well, I mean, it seems to me that it comes in as other matters evidence because it's relevant as to, the jury's determination of the appropriate sentence after the aggravating circumstances have been weighed against mitigating. Let me just add, what was the instruction again? Do you have that?
You have that, Tom?
I do, and I would note, Judge, if you read Summers, it's the last two paragraphs of Summers, they say the dissent and the concurrence say the Supreme Court someday may find that the aggravating circumstances confrontation clause may apply. However, even assuming that's true, we could instruct this way. They are not in any way suggesting that that instruction is an appropriate instruction in this case. If you want to read the Evans instruction, that would be one thing, but the instruction that they referenced in Summers is not one that they're saying would ever be given until the Nevada, or until the U.S. Supreme Court decides the confrontation applies to the aggravators of the eligibility, what they call the eligibility phase. You got to read the last two paragraphs of Summers together in the majority opinion to understand what they're saying.
The last two paragraphs of the concurring opinion?
No, last two paragraphs of the majority opinion where they say the dissent and the concurrence say this is going to happen in the future, and thus our unbifurcated penalty hearing is unconstitutional. Then they go on to say, even if that happens, it won't be unconstitutional because we can give this limiting instruction. But certainly under the state of the law as it is now, that instruction is not appropriate.
Let me see the instruction again.
This, and all this is the stock instruction on evidence admitted for one purpose and not another, where we try to modify it, and it has to be modified for the specific thing. Good. I guess I should have cited.
So you're introducing at least some of this evidence in reference to the aggravating factor of depravity of mind, that being either mitigation if I allow physical abuse beyond killing.
Yeah, as well as he may have addressed the two priors too, which are also related to the two aggravators.
Can I just interject something that
I'm sorry, he's going to introduce what? I didn't.
He may address the two priors too, the 84 and 86 priors.
Okay. All right, go ahead.
there was a case in the Nevada Supreme Court case called Tavares, Tavares v. State, and I can't read where the site is. Do we have it? Yeah, okay. 117 Nevada 725 2001. All that basically says is that upon proper request, well, actually, it says upon proper request, a limiting instruction must be given, and then it says with uncharged conduct evidence, it's the obligation of the state to provide the limiting instruction. We're asking for the limiting instruction now. Obviously, when we settle an instruction, we'll ask for the the appropriate structure. This is where we question the limiting instruction. And I'm getting, well, you didn't want to talk about the depravity of mind now, you wanted to wait.
Yeah.
Okay. All right.
If the court is crafting their own instruction, Evans has a mandatory limiting instruction that's given at the end of the case.
No.
Just so you know, you're first up.
Okay, you want to give me what you're proposing out of Evans?
So this is, and Mr. Pesci, just here, I'll read you what Evans says. For future capital cases, we provide the following instruction to guide the jury's consideration of evidence at the penalty hearing. And it says, it's in the packet I sent you, Judge, it's probably about, how many instructions in, about 7 instructions in. Determining whether, in deciding on an appropriate sentence for the defendant, you will consider 3 types of evidence. Evidence relevant to the existence of an aggravating circumstances, evidence relevant to the existence of mitigating circumstances, and other evidence presented against the defendant. You must consider each type of evidence for its appropriate purposes. In determining unanimously whether any aggravating circumstances has been proven beyond a reasonable doubt, you are to consider only evidence relevant to that aggravating circumstance. You are not to consider other evidence against the defendant. In determining individually whether any mitigating circumstances exist, you are to consider only evidence relevant to that mitigating circumstance. You are not to consider other evidence presented against the defendant. In determining individually when any mitigating circumstances outweigh any aggravating circumstance, you are to consider only evidence relevant to any mitigating and aggravating circumstances. You are not to consider other matter evidence presented against the defendant. If you find unanimously and beyond a reasonable doubt that at least one aggravating circumstance exists and that each of you determines that any mitigating circumstances do not outweigh the aggravating circumstance, the defendant is eligible for a death sentence. At this point, you are to consider all 3 types of evidence, and you still have the discretion to impose a sentence less than death. You must decide on a sentence unanimously. If you do not decide unanimously that at least one aggravating circumstance has been proven beyond a reasonable doubt, or if at least one of you determines that the mitigating circumstances outweigh the aggravating, the defendant is not eligible for the death sentence. Upon determining that the defendant is not eligible for death, you are to consider all 3 types of evidence in determining a sentence other than death, and you must decide on a sentence unanimously. That's the required instruction. Now, it doesn't make a lot of sense to do it during the testimony, and I've never seen it done during the testimony. I guess the court could read that to the jury, but they don't have any idea what an aggravating or mitigating circumstance is or anything like that. The jury is believed to rely upon, and they make the determination, by the way, as to what exactly is relevant to an aggravating circumstance versus what is relevant to other matter evidence. And so I don't know how the court would limit it other than just reading that instruction, but it would be somewhat confusing.
I mean, let's see, looking at what the defense provided, you're about to hear evidence concerning details of the conduct and the investigation of conduct underlying the defendant's conviction in this case. I instruct you that this evidence, other than evidence concerning the defendant's physical abuse of the victim, is admitted only for the limited purpose of aiding the jury in determining the appropriate sentence after any enumerated aggravators have been weighed against any mitigating circumstances.
I actually don't have a problem with that instruction.
Evidence concerning defendant's physical abuse of the victim may be considered in determining if the state has proven an aggravating factor beyond a reasonable doubt, and also for aiding the jury. in the determination of the appropriate sentence after any enumerated aggravators have been weighed against any mitigating factors.
Could you read that last sentence again?
All right. You're about to hear evidence concerning details of the conduct and the investigation of the conduct underlying defendant's conviction in this case. I instruct you that this evidence, other than evidence concerning defendant's physical abuse of the victim, is omitted only for the limited purpose of aiding the jury in determining the appropriate sentence after any enumerated aggravating circumstances have been weighed against any mitigating circumstances. Evidence concerning defendant's physical abuse of the victim may be considered in determining if the state has proven an aggravating factor beyond a reasonable doubt and for the purpose of aiding the jury in determining the appropriate sentence after any enumerated aggravating circumstances have been weighed against any mitigating circumstances. All right, we hear defendant's comments. And looking at the cases, it does seem very clear that the Nevada Supreme Court has said that hearsay evidence can be considered in determining whether an aggravating factor exists. And that's a 2015 case, which Burnside, which the state has cited. So whether I concur completely with that or not, that's what the state Supreme Court has found. Looking at the other cases, such as Thomas and everything, I mean, I think I can direct the jury, and if you want me to, I'll go ahead and direct the jury, that evidence relating to the conduct of the defendant's conduct and the investigation of his conduct is, other than that relating to defendant's physical abuse of the victim, is only omitted for the limited purpose of selection. So, do you want me to do that?
Yeah, we're requesting the limiting instruction. I'm sorry, you took that. I thought my phone was
Okay.
off. It just went. But I think I have to, and when you use the physical abuse, are you using the physical abuse as the depravity of mind?
Well, I mean, you know, so since I'm going to allow at least mutilation, I haven't done a ruling yet on physical abuse generally, but, you know, the issue is whether the evidence of physical abuse can be considered in determining whether the state has proven mutilation, and if I expand it to physical abuse beyond that necessary for the killing, or beyond that necessary of the killing.
Well, then we'll argue that part.
Okay, all right.
I wasn't sure when you used that phrase, physical abuse, what you were.
I'm saying the jury can consider any evidence of physical abuse in determining whether the state has met its standards under depravity of mind, whether I limit it to mutilation beyond that necessary for killing, or expand it to physical abuse beyond that necessary for killing.
Okay.
All right?
So-
Okay, let's bring in the
So
jury.
you're going to be giving that limiting instruction?
Yep, I will give that right now.
Thank you.
You want to go to about 12:30 for giving the order?
Probably.
Okay. I'll let you know around 12:30 where there's a ship for you.
All right, maybe even go 12:45, so.
All right, is there any? Everyone drawn?
All right, let the record reflect the presence of the attorneys for both sides, the presence of the defendant, and the parties stipulate to the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
All right. Thank you for your patience with us, ladies and gentlemen. I apologize for the delay. We're going to get back to moving right now. Before going on with the testimony of this witness in this case, I did want to give you what we typically refer to as a limiting instruction, and instruct you that you are about to hear evidence concerning details of the conduct and the investigation of the conduct underlying defendant's conviction in this case. I instruct you that this evidence, other than evidence concerning defendant's physical abuse of the victim, is omitted only for the limited purpose of aiding the jury in determining the appropriate sentence after any enumerated aggravating circumstances have been weighed against any mitigating circumstances. Evidence concerning defendant's physical abuse of the victim may be considered in determining if the state has proven an aggravating factor beyond a reasonable doubt, and also for the purpose of aiding the jury in determining the appropriate sentence after any enumerated aggravating circumstances have been weighed against any mitigating circumstances. All right. With that instruction to the jury at this point, go ahead with the testimony of the witness.
Yeah, I'm just gonna wait for the court reporter to put it back on my computer. Detective, I think I left off with, just about to start with our crime. So the jury had just heard from Edgar Stubs. Do you know who Edgar Stubs is?
Sure.
Who is he?
He is a retired police officer and served during the same time I did.
And he took us up to the point where he located the car, looked in and saw the foot of Ms. Blackwell. And then he said that he made notifications to a supervisor and then called G units.
That's
You know what he was talking about?
Yes, that's exactly what occurred. He made that notification via radio to the supervisor, and then that supervisor would contact dispatch requesting that G units or general assignment units respond to that location for that preliminary look at to determine if this is a crime where homicide should be called out.
And is that a standard practice that happened at Metro and happened for some period of time after 1986?
Yes, I believe it happens to this day.
So after the G units get there, the general assignment detectives, you weren't one of the general assignment detectives that responded to this call.
No, I worked a later shift on that occasion.
After the general assignment units got there, did they draw a conclusion as to needing other services?
Yes.
And what did they do?
They determined that they had what appeared to be a human being inside the vehicle that Officer Stubbs had located. And based on that, right there, they considered a possibility of foul play and contacted the on-duty homicide detectives that would respond on that date.
And does homicide then, when they get there, do they take over the investigation?
Yes.
Now, when you have a crime scene such as this, are there other units that are called out to process it?
Yes, these are our crime scene investigators that come out. They work in conjunction and at the direction of the homicide detectives to take responsibility for the scene and for the victim.
This particular vehicle, was it towed to be processed?
Yes.
And where does it go?
On this occasion, it was determined that the victims should remain in the vehicle, and the vehicle was towed to the crime lab directly from the location.
And then once that happens, is to the homicide detective or a homicide detective remain at the crime lab with the crime scene analysis they process with the scene?
Right. Typically, there's a detective that would remain at the scene after the vehicle is removed to look for any type of evidence that might be around the vehicle. And then another homicide detective would go with the vehicle. There's always someone with the vehicle all the way to the lab.
Now, you had an opportunity to see, well, all the pictures of the processing of the vehicle at the lab, but in particular, the ones that were admitted in this particular case.
Yes.
Okay, Judge.
Go ahead.
I'm going to show you what's been marked as state's proposed exhibits 2, 3, and 4, and I would note for the record they were admitted as well during the guilt phase under the same number, 2, 3, and 4.
You have these, right, Mr. Harrison?
Yes, Your Honor.
Okay, go ahead.
Do those appear to be photographs taken at the crime lab of the processing of this blue transfer?
Yes.
Move to admit 2, 3, and 4 for purposes of this hearing.
Any objection?
I just need to look one more time. Will you?
Sure.
Yeah.
Can I ask a question on board there?
Go ahead.
Mr. Vaquero, these three photographs, are these the photographs that you've seen in reviewing the files?
Certainly in reviewing the files, but I don't know if I saw those on an earlier proceeding related to this matter.
All right, then let me even back it up. You did not see the events depicted in these photographs personally?
I wasn't present in the crime lab, no.
So these are just photographs that you, when you went and reviewed at a later date the file, these were photographs that were in there.
That's correct.
So you're not saying that you ever saw any of this at the time?
That's correct.
Okay. Then I have no objection to
All right,
that limitation, well, with the limitation the court has placed on hearsay.
all right, go ahead.
So I'm gonna put up for you State's Exhibit number
Yeah,
2.
There'll be a minute, let me just, instead of go ahead, let me just make formally for the record, there'll be a minute.
Thank you.
Can I just run up here and do it, so we don't have to go back there, just one clarification I want.
You want to talk to me?
Yes, without having to do it, huh? Don't worry, I'm not gonna hurt you.
All right, no. Come on, all right. All right, what were those three exhibits again, Mr. Duff?
It was 2, 3, and 4.
All right, other than the objections already previously on the record, is there anything else from the defense?
No.
Okay, 2, 3, and 4 will be amended.
I'm gonna put up for you Exhibit number 2 and ask you, what are we looking at?
We're looking at the side of a blue Pontiac Trans Am. This is the driver's side with the door in the open position. And we can see what appears to be bedding or some kind of material on the back seat of the vehicle there.
As the vehicle is being processed, and I'm going to zoom in now to sort of the floorboard down here, was there some evidence on the floorboard of her vehicle as well as contained within the bedspread that was noted and relevant ultimately in the investigation?
Yes, here on the floor, it's a little blurry, but there are numerous pieces of gravel that people commonly refer to as pea gravel. It's a small gray substance that later became an important factor in the case.
Let's move on to State's Exhibit number 3. What are we looking at?
Here, the crime scene investigators, in the presence of probably the coroner's office at that point, are removed this wad of bedding material, which contained a human being, to this sterile sheet on the floor of the garage from the vehicle.
And once that is sort of unlayered, within that they find Karen Blackwell.
That's correct.
And she is in a pretty, well, how would you describe her state of decomposition?
We will see her as decomposing for some period of time. She's blackened and basically unrecognizable facially at that point.
Now, within that blanket, did the crime scene analysts collect a number of hairs, fibers, those type of things?
Yes, it's a slow process, and as the layers of the onion are peeled back, so to speak, the bedding becomes an evidence item, as well as fibers that are attached to it. And there were hairs that were associated with this bedding. Human hair, would appear to be animal hair, and also more of this gravel that we just spoke about.
And so the jury can tie this up later. Was the crime scene analyst named Bob Rees?
Yes, he is one of them.
And then Bob Leonard, the detective, was also present as well during this process?
That's correct.
In addition to the hairs and fibers, was there a bloody sock found in the bed?
Yes, there was. As I recall, it was sort of a athletic sock, if you might call it that. It had a ring, a colored ring on top of it. I think it was a red colored ring on the top of the sock.
Eventually, after they remove all these items and document all these things, putting up for you State's Exhibit number 4, did they then document sort of what the bedspread looks like?
Yes, once the victim's been removed from the bedding, things are slowly spread out so that they can examine them for maybe defects in the material or some type of trace evidence that's on the bedding. And here we have the bedspread stretched out for that examination and the photographs that were taken of it for evidence.
And lastly, before I leave this, the nature of the hairs that were found, there were blonde hairs, black hairs, as well as what appeared to be white and black animal hairs that were on all this bedding and blankets and stuff.
That's correct.
So once all of this is unraveled, as you said, peeled the onion, what happens to the body of Karen Blackwell?
Karen Blackwell is then right there in the crime, in the crime lab, and in the presence of the mortuary that's responded and the coroner's office investigator. She's then placed into a body bag and placed into one of the vehicles to be transported to the coroner's office for an autopsy, because this is an unattended death, or at least it seems to be a criminal matter, and a full autopsy is going to take place the following morning.
At an autopsy, who's present?
Well, typically we start with forensic assistants who will receive the body as it arrives at the coroner's office, and then they will prepare the body for autopsy by removing the body from the body bag. There are numerous photographs taken during this process. A seal that's on the body bag that was placed in the crime lab is removed by them, then photographed. All of this is for continuity of evidence. And then once the body is prepared and placed on a table, the body is brought into a separate room, and the process begins with the doctor being present, that forensic assistant who's also present, and typically one or both of the homicide detectives are there, along with crime scene investigators who are also documenting photographs. So you have two photographers in there. You've got your coroner's office taking photographs, and you've got your crime lab or our crime scene investigators taking photographs.
And the crime scene investigator that was at autopsy on this particular case was crime scene analyst Roger?
Yes.
So once the sort of the processing of the body goes through, you said there's a series of photographs taken, both when she's clothed and when she's unclothed, and then you document the various injuries.
Yes.
May I approach?
Go ahead.
Detective, I'm going to show you what's
You
been
showed
marked.
these to Mr. Erickson, right?
I did. Showing you what's been marked as State Proposed Exhibit 5. Through 10, and then 12 through 19, and ask you to flip through those and see if you recognize what's depicted in those photographs.
Yes, I do.
Those appear to be autopsy photos taken of Miss Blackwell, from one where she's even clothed, and also demonstrating what her injuries were.
Yes.
And Judge, I would note that the numbers from the trial 88 and these numbers are the same, and I would offer 5 through 10 and 12 through 19.
Any objection other than those previously stated?
No,
All right, 5 through 10 and 12 through 19 will be admitted.
Now, I'm going to start with State's Exhibit number 5 and ask you to describe what we're looking at here.
This is one of the first photographs taken after Karen Blackwell was removed from the body bag. And I can determine that by the fact that she still has clothing on, and it's part of the process prior to the actual autopsy beginning.
Can you tell us, because we don't have a photograph of what clothing she was wearing versus not wearing, can you tell us generally how she was dressed within that blanket?
Yes, she had sort of a bodysuit on that was sort of a thong style between the crotch, a one piece that went up through open arms and shoulder straps. So it was just one piece lace, white lace bodysuit.
Was her skirt ever found?
Not that I know of, no.
And was there a blouse off her body that was within the bedspreads as well?
Yes.
So she has this sort of one piece undergarment, for lack of a better term.
Yes.
She obviously has some gold chains, and then within this photograph there's an orange zip tie, for lack of a better term. Can you describe that for us?
Yeah, this is a common thing. We see a plastic tie that's used in different things, industrial work, possibly refrigeration, to tie a ductwork together. and you slip one end through a ratcheting head on the strap, and then as you tighten it down, it holds whatever you're trying to hold in place, and it won't back out. It's a one-way deal, and the only way to get it off is to cut it off.
And the description in the reports, as well as this photograph here, the tie doesn't appear to be tied down tight, as in a ligature type situation. Is that fair?
Yeah, that's fair. It's loose.
It's loose. And the descriptions in the reports, as well as the autopsy, suggest there's no hemorrhage underneath there, like it was used as a ligature.
That's correct.
Madam Court Reporter, I'm going to have you flip over to this for 6 because on my computer it's not exactly the same shape. So now I'm going to move on to State's Exhibit number 6 and ask you, generally, what are we looking at?
This is a photograph, obviously, of a gloved hand during autopsy by probably the forensic assistant, holding a ruler for measurement of the size of the injury that we're looking at on the skull of the victim. We see that during decomposition, often human hairs will slough off the skin and just fall off by themselves. But it appears also that there's some shaving that took place here, so I can see shorter hair. And that would be so that the wound could be observed and measured properly.
And the reports reflect that this is blunt force trauma to the head of the victim?
Yes.
And when we use the term blunt force trauma, what are we talking about?
We have different types of trauma that can occur. In a blunt force trauma, you have a hard object that will cause the skin to split in ragged edges instead of an incised wound, which would show a more linear shape, like a knife would make. And so blunt force trauma is something hard hitting the flesh and creating the situation where it could burst open.
And so it appears that Karen Blackwell had hit her head, or someone hit her head with something hard, causing this laceration to the top of her head.
That's true.
In addition to that, Madam, we'll go back to my computer now. In addition to that, in exhibit number 7, did Miss Blackwell have 8 stab wounds to the top of her head as well?
Yes.
And this may be self-explanatory, but for the record, the difference between a blunt trauma versus a stab wound is what?
Well, basically, we have an instrument involved with the incised wound or the stab wound. And in this photograph, you can see on the top right of the damaged area more of that linear shape that I've described that would indicate that a weapon or some type of a knife was used. Something sharp was used to create that wound. And they are completely different in shape, and their margins are completely different than blunt force trauma.
And looking at the records, these stab wounds didn't penetrate the skull. Is that fair?
Yes, that's true.
And in your time as a homicide detective, stabbing somebody in the head and not penetrating through the skull, is that a very effective method of killing someone?
Objection, Your Honor. Cause the speculation.
Sustained.
Let me ask you this, in your time, how many times have you seen people with injuries to their head?
I have seen numerous injuries to the head.
Have you seen sharp force injuries to the head?
Yes, I have.
Have you seen sharp force injuries to the head that have not penetrated the skull?
Yes.
And sharp force injuries that have not penetrated the skull, in the times that you've seen them, have they usually resulted in the death of an individual?
No,
Objection,
no.
Your Honor. Once again, he's speculating. If it's supposed to be a summary witness testifying to a review of it, that's one thing. And him talking about other cases is another.
I'll sustain that.
Let me move on now to State's Exhibit number 8. What are we looking at here?
Here we have a photograph with the assistant gloved hand pointing towards a wound that had a particular characteristic that the doctor, he wanted the doctor or she wanted the doctor to be aware of, along with our tape measure.
And so, and it's hard to see on these 1986 versions. but they appear to be documenting a stab wound behind the left ear of the victim.
Yes, you can see that the finger of the assistant there is holding the ear folded over and identifying that injury with the ruler very close to it.
And State's Exhibit number 9. What are we looking at?
Here we have our victim face down on the table now. You see a block that is used sort of like a 4-inch by 4-inch rubber block that's underneath the neck. And that's exposing the back side of the neck of the victim where additional what appear to be incised or knife-related wounds are in a cluster right where the shoulders and the bottom of the neck come together.
Now these particular wounds here were described by the medical examiner as stab wounds.
That's correct.
So some sharp knife-like object caused these particular wounds.
Yes, we can see the edges are defined, not ragged like in blunt force trauma, and they're in a cluster there, close together.
So now I'm going to flip to the front of her neck on the State's Exhibit number 10. What are we looking at?
Here we have another small grouping of incised wounds. I believe it's in the neighborhood of 8, and they are also have the same characteristics with those smooth edges that would be from an incised wound.
The nature of the wounds in this particular place, the way that they are grouped together, and there doesn't appear to be sort of in and out, in and out, in and out without any deviation from it. Does that suggest anything to you?
In my experience, it suggests close quarters.
I would object.
What's that?
Offering his opinion as what it suggests to him, he's supposed to be articulating a summary of what the evidence from the coroner was.
Lay a little bit more foundation, but I'm going to let you go there. I think this is that we can indicate what the general nature of what the activity is that the person is safely engaged in.
And I'm going to get to this, detective, sort of in a broad view, but in particular on this, you said that you believe that this demonstrated that there was close quarters. Let me ask you, in the time that you've been a detective, when people are being stabbed and they are thrashing about trying to get away from it, do you get this type of grouping usually in your nature of your stabbing?
Objection.
No, Oliver will.
Not in those circumstances.
So this suggests that she's not moving at the time that she's receiving some of these grouped up injuries?
Yes.
Objection, no speculation.
Overruled.
State's Exhibit number 12. What are we looking at?
Here we have our victim head to the left, face up again, and we have a measure or small ruler placed on top of her body beneath her right breast, and that is there to document 8 additional incised close quarter stab wounds.
And then State's Exhibit number 13 documents the 8 to the left breast as well.
Yes, it does.
Now, State's Exhibit number 14. What are we looking at?
Here we have our victim, head to the right. The ruler is been laid upon her stomach, and it is documenting the incised wounds punctured in the abdomen area.
She has punctures in her stomach, and then number 15, does she also have a single puncture wound to her back?
Yes.
And that's documented in State's Exhibit number 15.
Yes.
I'm going to skip 16 for just a second and now jump to 17, 18, and 19. As a detective, have you heard the term defensive wounds before?
Yes, of course.
Can you describe what that is?
Typically, these are injuries that we see our victims have, alive or deceased, that are their effort to prevent the damage from occurring to their body during an attack. They mostly happen on their hands and arms as they're trying to protect themselves during that attack.
And does Ms. Blackwell have at least a few defensive wounds?
Yes.
So let's start with 17. She has a wound to her left arm.
Yes, this is her left arm. You can see her fingers in the top of the photograph, elbow to the left in the photograph.
She has a wound number 18.
Here we have another on the right hand. You see her fingers to the right, and the ruler's been placed up by her knuckle on top of her hand.
And then 19 is that the left hand.
And we have the left hand, and damage to the top of the hand as well.
Other than those that we've seen in these 3 photographs, those are the only defensive wounds she has, despite the 45 or so wounds to her body.
Well, that we could see with that level of decomposition. There could have been other bruising, contusions, or even abrasions.
Speculation.
Sustained.
And finally, State's Exhibit number 16.
I'll sustain it, I'll sustain it after the answer to what we could see in the photographs. The remaining of the answer all were stricken, or the jury disregarded.
What are we looking at in State's Exhibit number 16?
Here we have a photograph of our victim, her upper body to the left of the photograph, and her 2 legs. This is her vagina area, and at the top of her pubic arch we have a ruler which has been placed to document the distance and the size of the damage by that incised wound that's right below the ruler, about a third of the way up.
So the victim has a stab wound that penetrates the labia majora and into her vagina.
That's what I understand from the report, yes.
Once sort of the autopsy is completed, in your standard everyday homicide case, how do you go about, or how do these detectives go about investigating the death of Ms. Blackwell?
Well, a lot of things start happening the second that the body is found. The location is important because then a canvass is started, people talking to people in the neighborhood where the vehicle's found, and in this case, it was at an apartment complex on South Maryland Park. Also, the car has a serial number and a license plate. So we try to determine who's the registered owner or owner of the vehicle, and then we work from that little area. We start working our circle out, trying to determine who is known associates with our victim once we've identified our victim, and then the ball just keeps rolling depending upon the direction it takes us.
At autopsy, are there fingerprints taken of Ms. Blackwell, and is she ultimately identified as Karen Sue Blackwell?
Yes.
Once you've identified your victim, do you do something which is called victimology?
Yes.
What is victimology?
Victimology is the study of the victim. Criminology would be the study of a crime. And in victimology, we look into everything we can find out about our victim to try to determine what her world is like and who she's been involved with or encountered in the last period of time. We see this level of decomposition, so we know that we have a problem with time because we know that she's been deceased for a period of time. So that opens up that victimology a little bit more because we know we have a bigger range of time.
Ultimately, once they find out that it's Karen Blackwell, do they locate a missing persons report that was entered on September 21st of 1986?
Yes, in association with the running of the license plate on the car, the computer shows that there is a person listed as Karen Blackwell as a missing person associated with that very same vehicle.
And when they looked that up, the person reporting is a man by the name of Roger Blackwell?
Yes.
And who is Roger?
Roger Blackwell is the ex-husband of our victim, Karen Blackwell.
And did Roger and Karen have any children in common?
Yes.
Who was that?
They have at the time, a daughter that was 9 years of age, Summer Blackwell.
And do the police reach out and contact Mr. Blackwell to find out the circumstances of the missing report and what him and his daughter might know about the death of Miss Blackwell?
Yes, the detectives would interview the ex-husband as well as the daughter, and learn more facts about the case.
Now, contained within the case file, were there some photographs of Ms. Blackwell along with Roger in one of them, Summer in some of the other ones, of sort of what she looked like in life?
Yes.
I'm showing you what's marked as State Proposed Exhibit 20, 46, 47, and 48. I can tell you if those appear to be photographs of Miss Blackwell in real life or in life before her death that were contained within the case file.
Yes, I recognize these photographs.
We do have objections to some of those photos.
Okay,
Gonna offer.
so I figure you're gonna offer. We need to have a sidebar?
Yes.
All right. I have those photos, please. Thank you very much. Go ahead, Counsel.
Thank you. So for the record, you're admitting 20 and 47?
Any other objection to those previously stated?
No.
All right, 20 and 47 will be admitted.
Next, I'm going to put 47 up here. This is a picture of Karen with Summer at a somewhat young age and Roger Blackwell.
Yes.
Now, when Roger Blackwell is contacted, what is he able to tell the police about his wife and her activities?
Roger Blackwell informs the detectives that his wife, Karen, is a prostitute, and that is her profession in the Las Vegas area. He also tells them that she's meticulous about what she does. It's in the fact that she keeps a book, which she called a trick book. And this book contained the names and phone numbers and locations, and even some behavioral traits of people that she would make contact with over the phone, and then ultimately date as a prostitute.
Did he explain to them that she would normally place ads in the newspaper? I know it's weird to think of ads in a newspaper these days, but that she would place ads in the newspaper with listings and various names in order to get to customers?
Right. Typically, Karen Blackwell would have these ads placed in the local newspapers. They would be 3 or 4 lines. They would consist of a name, a telephone number to call, and something to pique the interest of the reader apparently. These ads we were able to determine were in several different names, but always the same phone number, so she had a habit of using a different name in a different ad. So she had like 3 ads at a time in the paper with different names, but it was always the same phone number.
And Judge, in my hand, I have what was previously admitted at the prior proceeding as State's Exhibit 77. It has now been marked for this proceeding as State's Exhibit number 55, which is a newspaper with appears 3 blue circles on it I'd offered at this time.
Have you shown it to Mr. Erickson?
I have. We went through all these the other day.
Okay. Any objection? Other than what you previously put on the record?
No additional.
All right, then
Objection.
I'll go ahead and admit. What's the number again?
55.
55.
So, Detective, I'm going to throw up here sort of pictures we took of this exhibit previously for you. Or I'm going to have to go to the door because it's not coming up. So, looking at Exhibit 55, and I talked about the blue circles, and let's see if I can zoom in on this. It's a little blurry, but it appears there was ads in the paper that read a very sexy girl with the European look called Eva at 386-8649.
Yes, that's correct.
And it's the number that detectives were able to use to locate those various ads because the number stays consistent between the various ads.
That's correct. It was learned that this is Karen Blackwell's work number. There were 2 phone numbers associated with her residence, and this was her work number, according to what we learned during the investigation.
And then there's 2 more ads. Once again, for a sweet hot fire, call Fiona now, 386-8649.
That's correct.
And then long-legged, shapely, slim, pretty girl, call Kelly for dates, 386-8649.
Yes.
In addition to directing the police to the ad, did Mr. Blackwell turn over maybe more than one, but at least one red trick book?
Yes.
And this was the document or the book that he said that she would keep meticulous notes of her various business encounters with men.
That's correct.
And Judge, I would note that at the prior proceeding, this was admitted as State's Exhibit 54. It's marked as 50 for this particular proceeding, and I would offer it at this time.
All right. Any objection other than those previously stated, Mr. Erickson?
No.
All right. That will be 55 will be admitted. So what was the number? 50, sorry. All right, 50 will be admitted.
So this red book, when you were to go into the various pages, and this one's upside down, so I'm going to have to move it. When you go into the various pages, you would see a bunch of handwriting, and it looks sort of made out in columns. Is that correct?
Yes.
And so on the left-hand side, there's a female name, like Roxanne and Alicia, and looks like there's a Rochelle in here as well. Did you know what those female names, or did Mr. Blackwell sort of explain what those female names meant?
Yes, it was learned during the investigation that this was Karen Blackwell's formula for her trip book to keep track of what she was doing in her profession. The first name would be the name that someone called responding to that particular ad. So if she got a phone call off of the ad as Roxanne, she would write down Roxanne so that she would remember to use the correct name and potentially which names worked better for her. The next name on the same horizontal line was the caller, the name of the caller, typically the first name. If you see only a first name, it was because there was potentially not a date. She was meticulous about getting a full name, a location, and then calling back so that she could determine that this person was truly a date and not a police officer or something else. As we move across horizontally, you see the phone number that the person provided her with so that she could call back, and then a note. In some circumstances, will call back, or someone apparently said it was too much money or too much something, and wrong number, someone called and got the wrong number. So there was a formula here to what she was doing. We also learned that she would use different colored pens to differentiate the phone calls for a particular day. So when the pen color would change, it was particularly, it was obvious that it was another day's with phone calls. And then we have stars and circle stars. And these were actual dates. These were individuals that, the first star that we see, Alyssa, a star was next to the name Charlie with a phone number, and then Central Park West. So we know that she vetted this person and went and had a date with him and put the star next to the name.
Now, on the bottom of this page, there's one that says Roxanne, and I'm going to go back to, it a little too quickly. Here's to say Roxanne John Valerio 796-7308.
Yes.
Now this particular entry is not sort of at the end of the book where it would be the last person that she had written into the book. Is
Right.
that correct?
That's correct.
Did Mr. Blackwell, and then ultimately they get to her boyfriend Barry Kozlov as well, is that correct?
Yes.
That's Karen's boyfriend Barry Kozlov?
Karen's boyfriend at the time. That's right.
And did they explain if there was a repeat customer, whether or not we repeatedly see the same name?
Right, so in this circumstance, this is several pages back in the book. It shows Roxanne with a star and then the name John Valerio and the phone number that we just described. The star would indicate that she had a date with that individual and she had vetted him as not being a police officer and she didn't get in any trouble. If she was to date, we would learn, if she was to date that same person again, she wouldn't go through the whole process of entering the name, the star, the number, and so on and so forth, because she had already vetted this person. If they called and reminded her, she could just go to them.
And then as we go over to the left-hand column by Mr. Valerio's name, we'd see Trop in Paradise, Naples 432B. What did that information reflect?
Right, so that in association horizontally with the name John Valerio and the phone number is the location of the date, or where he has instructed her to come, which is Tropicana, near Tropicana, something about a left, I think it says there, and then Naples 432B, which is an actual address, 432 Naples, apartment B. It's a duplex, single story.
Does Mr. Blackwell explain how it is he learns on September 20th that his wife is, or his ex-wife is missing?
Yes.
What does he explain?
We learned that Mr. Blackwell is contacted by a friend that's a Virginia Pratt, P-R-A-T-T. She contacts Victor Blackwell to say that Karen has not come home to her residence after a date that she had the previous night. Mr. Blackwell's aware of her profession, and the 9-year-old daughter, Summer, was at the residence, and on this particular night, a neighbor girl, 11 years old, came over to play with Summer, and it was at that time that Karen Blackwell had come home from a date with McDonald's for her daughter, and shortly after that, she received a phone call, and that was on the work line, and she said to her daughter, "I have to go out, I'll be back in an hour and a half." So she left the 9-year-old daughter and the 11-year-old in the apartment that she lived in and went back out on this date.
The next day, Virginia comes over and she finds Summer alone, and that's why she decides to call Mr. Blackwell.
That's correct.
Now, was Mr. Blackwell aware that Karen Blackwell had a boyfriend that lived in Texas?
Yes,
And that's the Barry Kozlov that you talked about?
Barry Kozlov, that's correct.
Does that lead detectives to interviewing Mr. Kozlov to see if he had had any contact with Karen the night of the 19th?
Yes.
And what does he explain?
He explains that she contacted him. She had just come home from a date. He also was aware of her profession. And she was upset but had to go out on one more date because it was in the same area she had just come from. And that was her words to him. He related that to the detectives.
And does he tell them that the area is in the area of Trop and Pecos?
Yes. No, Trop and Paradise.
Trop and Paradise.
Yeah, not Trop and Pecos.
So she's in the, she had just come from the area of Trop and Paradise, and now she has to go back to that area.
Correct.
Ma'am, can I have you throw it into the document cam? I'm gonna put up a page that I don't have scanned in here, so, State's Exhibit number 50. Sort of the last star that they find in the book before someone starts making notations about missing persons and all the other stuff is to a Ron on Naples, and with a phone number, is that correct?
Yes.
After talking to Mr., well, let me ask you this first, is Naples in the area of Trop and Paradise?
It is.
You put it back on there. After talking with Mr. Kozlov, and they look in the book and they see Ron, they see Naples, and they see that's in the area where she had come from, do they identify somebody named Ron Castle?
Yes, they did.
And who is Mr. Castle?
Ron Castle is the gentleman that was in the trick book. He was that entry that we just saw up on the screen. The phone number was correct. It was his phone number, and detectives contacted him and learned that he had been in the presence of Karen Blackwell on the night that she went missing. So that would have been the 19th She was apparently the person that, she said, I had just been in that area, and now I have to go back to that area. So she was the person that, or he was the person that she was there first for. He resided at 410 Naples. I believe it was apartment 6, and this is a multiple unit, 2-story apartment complex, which is, even though the numbers don't seem to jive, right next door to 432.
So 410 Naples is right next door to 432 Naples.
That's correct.
And so after the detectives talked to Mr. Castle, and Mr. Castle explains that Ms. Blackwell was there between 8 and 9:45 at night.
That was the timing that he gave, that she departed about 9:45.
That as they're leaving this particular interview, do they do something when they see that it's right next door to 432B?
Well, they're doing the interview right there on Naples at 410. They get done talking to Mr. Castle. They come out to the street and they realize that pages back in the book that they had examined was an address on Naples at 432B. And because they were within 30, 40 feet of that address, they decided that they would go over to that address, knock on the door, and make an inquiry to see if there was an additional John or a customer for Karen Blackwell.
Now, when they initially go to 432B, who do they find?
They knock on the door and they're greeted by a Brenda Gagliardo. She says that she's the resident there, and they talk to her about John Valerio, because John Valerio is the name associated with the entry in the trick book for 432 Naples Apartment B.
And does Brenda initially tell the police that John is not there?
Yes.
Later on during the jury trial, does Brenda testify that John was there?
Yes, that John was there, and asked her not to tell anyone that he was there.
When the police see Miss Gagliardo, well, first of all, when they're walking up to the residence, do they see something that might be relevant to their investigation?
Yes. As I said, as they were leaving Ron Castle, they noticed the address was close, but as they walked up to 432B, they saw this front yard had been landscaped with this gray pea gravel, which they had seen associated with the rear floor mat of Karen Blackwell's Pontiac Trans Am, and also wrapped up in the blanket that her body was wrapped around her body rather than the backseat of the car. So this gray pea gravel was present in front of 432 Naples B, and the same stuff that they saw in the car.
When they're talking to Brenda, is there something about her hair that catches their attention?
Yes, she had long blonde hair, and this was similar to the hair that they had seen in the bedding as they were doing those examinations at the crime lab.
And did they see a beware of dog sign?
Yes, they did. And when they saw the beware of dog sign, they asked her if she had a dog. She said yes, she did. And they said, could we see your dog? And she showed them the side of the house where they could observe a shepherd-like dog, about 40 pounds. He was probably a mix because he had a white body and a dark head. And she said that that was her dog. And I think she had a cat too.
And were the black and white animal hairs, the blonde hair, the pea gravel, all something that sort of drew the detective's attention?
Yes, they all certainly piqued their interest because of the fact that these were several items that were discovered on the bedding that she was wrapped up with.
So did they leave her a card?
Pardon me?
Did they leave her a card?
A card, yes. So I think it was Detective Leonard left a business card and said, could you please have John Valerio, when he returns home, contact us. We want to talk to him about a friend that we're investigating. And I think they left it kind of vague like that.
The next day, is John called Detective Leonard?
No,
Okay. Who does?
Brenda Gagliardo.
And what does she tell the police?
Brenda calls Detective Leonard about midday, maybe a little bit later. She's concerned because after the detectives departed, she questioned John about, several things that were odd in the house, one of which is why he wanted to be hidden from the people at the door, and also the fact that there was missing bedding from her apartment, her bedspread that she had for years, and John had told her that the dog had thrown up on the bedding, and he had then put it in the washing machine, but she couldn't locate the bedding in the washing machine, so she didn't know what was going on. And she became concerned about the circumstances and called Detective Leonard.
And during the course of talking to Detective Leonard, did she ask Detective Leonard whether or not she had anything to be scared about or fear?
Yes, and Detective Leonard responded to her, "You really have no problem unless you're missing a checkered red and yellow bedspread from your bed." And to that, Brenda Gagliardo said, "Oh my God, I am." And that's when they decided that she would travel down to the police station and do an interview in depth with Detective Leonard.
Does she come down and give that interview?
Yes, she does.
During the course of that interview, does she explain to you, to Detective Leonard, sort of the circumstances of what was going on September 19th into the early morning hours of September 20th with her?
Yes.
And what does she explain?
Well, we learned that Brenda Gagliardo is a cocktail waitress at the Palace Station. She works a shift from 5 p.m. to 1 a.m. She said that on that Friday night, the 19th of September, she had left for work so that she could be at work early, which was her habit, about 4:30 to 5 o'clock. She said that when she left the residence, she was expecting to see John arrive at the Palace Station, which was his habit to cash his payday check at the Palace Station. And he did not arrive, that she was aware of that entire shift. She didn't know where he was. She said then that she was expecting him to pick her up from work shortly after her shift ended at 1 p.m., but that he arrived late.
Does she explain that she expected to see him between 8 and 9 p.m. during her break because she had her daughter there?
Right. He would typically visit her during her shift and just to visit, and on this occasion he didn't come.
And Brenda explained that she lives in 432B with Mr. Valerio, but also her 13-year-old daughter.
Yes.
And her 13-year-old daughter had actually gone to work with her the night of the 19th.
That's correct.
And then, did she indicate that when she attempted to call him at 1:15 when she got off, Mr. Valerio explained he'd fallen asleep?
That's correct.
And that he would be down to get her, which should have been about a 10-minute trip, but he didn't show up for about an hour and a half or something like that.
It was much later, yes.
After conducting this interview with Ms. Gagliardo, did they take her down and show her the bedspread?
Right, so once she is alarmed about the bedspread and discusses that in the interview, the detectives, to confirm that, take her and her daughter and a friend that was along, I believe. They take the three of them, or no, I'm wrong, I think the daughter remained at the police station with the friend. And Brenda Gagliardo went with the detectives to the crime lab, which was several miles away, and they went to where the bedspread was located, the one that we had seen in the photograph. And immediately she identified it as her bedspread.
The other thing she did during the interview is explain that at 432 Naples, number B, the phone number used to be 796-7308, which matched the trick phone with John Valerio.
Right, there was some confusion at first about that. The phone number had changed at the behest of Brenda Gagliardo. She had contacted Centel and asked for a new phone number at some point, and so there was some confusion there, but it was cleared up. The fact that the 796 number that we saw associated with John Valerio had been changed to 369-9097, just as a matter of business with Mrs. Gagliardo, or Ms. Gagliardo.
Now, once they learn all this information, Mr. Valerio seems like a fairly good suspect, is that correct?
I would say so, yes.
And what do the detectives decide to do?
The detectives at that point decide that they're interested in trying to locate him, and they also feel that they have probable cause to arrest him. So it was decided, it was now getting to be late in the day on the 20th, and they decided that they would establish a surveillance at the residence at 432 Naples, apartment B, to wait for John Valerio to arrive.
And I'm sorry, you just said on the 20th, is this October 3rd of 1986?
This is October 3rd, I'm sorry. I said the 20th, meaning the day after, but I'm actually behind from the discovery of the body, right, October 3rd.
She goes missing the 19th.
That's
She's
right.
found the night of the 29th into the 30th.
That's correct.
And then on the 2nd is the first interview with Ms. Gagliardo, and on October 3rd is the second interview.
That's correct.
Who is conducting the surveillance over at 432B Naples?
Well, there were several individuals initially responded to start the surveillance. I was one of them, in an unmarked police car in plain clothes. There was also a Detective David Hatch, who was senior to me and had been on the department for a long time at that time. There was also Lieutenant Greg Jolly present, and there was a sergeant named Mike Bunker as well.
Was there a district attorney that was out there for a period?
There was. There happened to be in the company of Lieutenant Jolly, a deputy district attorney by the name of Tom Lean, and he came along due to the circumstances of the case.
Eventually, do Mr. Jolly, or sorry, Lieutenant Jolly and Mr. Lean leave the location?
Right, there was a prior commitment, and during the stakeout, which was starting to get long in time, Lieutenant Jolly decided to remove from the area with Mr. Lean.
And then, I know this is 1986 and may sound a little strange, so did something happen with Sergeant Bunker being paged and now having to find a phone?
Right, so in those days we had to go find a public phone when you needed to make a phone call. And Sergeant Bunker received information via radio that the Palace Station had called the police department and had information about the case that they wished to give to the police. So he opted to pull off of the surveillance, and that left Detective Hatch on the street by the address on Naples by himself, because Sergeant Bunker rolled out to find a telephone to make a call to Palace Station.
And while Detective Hatch is alone, what happens?
While Detective Hatch is alone, he is roving around the area so as to not appear too static. This is a cul-de-sac, and in no time you could be observed. So he was rolling in the area, hoping to spot the arrival of John Valerio, and in fact he did. He saw a vehicle drive down the street, which we had known the description of that vehicle based on the information that we received from Karen or from Gagliardo, Brenda Gagliardo. And so knowing the vehicle, Detective Hatch sees the vehicle come westbound on Naples, and he falls in behind the vehicle with his police vehicle, which is unmarked, and he's a plainclothes detective. And he begins to effect a car stop on the sole occupant of the vehicle.
And it turns out that sole occupant is Mr. Valerio?
Yes.
And can you describe sort of the sequencing from there once Detective Hatch tries to stop Mr. Valerio?
Yes. Detective Hatch falls in behind the vehicle. He sees the vehicle accelerate quickly and go to the end of the cul-de-sac and complete a U-turn. Detective Hatch steps out of his now parked police car with a shotgun, department-issued shotgun, and he gets in the protection at first of his door to his vehicle, but then steps forward so that he's a little bit more illuminated, and he is now declaring towards the occupant of the vehicle that has come to a stop, that he's a police officer, and he calls out, "John, put your hands up, you're under arrest," because he knew the name of the individual he was trying to arrest. And at that point, the vehicle that he was challenging continued to make the turn and accelerated extremely hard, spinning the tires, and started to drive towards Detective Hatch.
And as he gets close to Detective Hatch, does Detective Hatch have to do some evasive maneuvering?
Yes, Detective Hatch is again announcing that he's a police officer and for the vehicle to stop. The vehicle doesn't stop, and it comes within, it starts getting very close to him, and he has to move up his body out of the way for the approaching vehicle. As he does that, he sees the driver looking straight at him. He says the driver now leans down in the seat as he brings his shotgun to bear. And Detective Hatch says that within a foot or two of his body, he fires a shotgun blast through the driver's window of the vehicle at John Valerio.
And how many times does Hatch discharge his weapon?
As the vehicle continues, Hatch chambers a fresh round, fires additionally on an angle into the back of the car, and then one additional round directly towards the rear of the car as it goes eastbound on Naples towards Paradise.
And the defendant at this time is sort of grasping the wheel and laying sideways with his left side exposed to that window.
Yes.
Once the shots fired call comes out, first of all, investigators go over there to process the scene, now the shooting scene at 432 Naples?
Right. Well, everyone that was on that surveillance just flooded into that area. to assist Detective Hatch. Detective Hatch had reboarded his vehicle, tried to take a pursuit of the Valerio vehicle, but when he got to the intersection of Naples and Paradise, he realized he couldn't see the car, so the best thing for him to do through training is to return back to the scene where he had an officer involved shooting, and he placed his car on the side of the street and his shotgun in a safe position in the car. Other detectives started to come to the area to protect the scene, and a broadcast was put out about what had occurred regarding the shooting and the suspect vehicle fleeing the area.
Once there's an officer-involved shooting involving Mr. Valerio, is Brenda, who's still with Detective Leonard, asked, hey, where possibly could this guy go? Because he obviously can't come home now.
Right, that's what happens.
And does she provide a name?
Yes, she says that John Valerio has a friend, a very good friend, and that he lives, his name is Billy Childers, and that Billy Childers lives on North Nellis, and that if he was going to go anywhere after something like that happened, he would go to Billy Childers' address.
And based upon that, what's the decision that was made?
Myself and other detectives formulated a plan that we would create a surveillance on the address of Billy Childers on North Nellis. And I enlisted teammates that I had in the past in SWAT to, because of their plainclothes and cars being unmarked, to go find the location, gave them information about the description of the suspect and the suspect vehicle, and asked them to stake out the location of Billy Childers' residence.
Eventually, do they see, were you given the identification of Billy's pickup truck that you'd be looking for?
Yes.
And eventually, do they see that pickup truck leaving Mr. Childers' residence occupied by two individuals?
That's correct. So now the vehicle that had been shot at is no longer in play. They don't see that vehicle there. But what they do see is a blue pickup truck that they associate with Billy Childers and two individuals, one of which matches the description that was given by Detective Hatch, because he saw this individual in the car, John Valerio, and we'd also had a description from Brenda Gagliardo. So one of these individuals coming out of Childers' house looks like John Valerio.
Do the cops follow this truck?
They do. They create a surveillance following the vehicle for a long period of time. One of the detectives associated with the case wanted to pull alongside of the vehicle so that he could visually look clearly at the individual to determine if it was John Valerio. At that time, most of us were in possession of a photograph of Mr. Valerio. And so we were trying to ascertain before we stopped the vehicle if that was in fact him.
Was there some confusion, but did he look differently than Detective Hatch had described him?
Yes. Throughout that early part of the investigation, right after the shooting, he was described as possibly a Hispanic male with a full beard. And the individual in the car with Billy Childers, or in the truck rather, did not have a beard but had a mustache. But one of the detectives did announce over the radio to everyone that it was approaching the area of the Naples residence. They were coming back to that area, and that the individual in the vehicle was in fact John Valerio.
Does the vehicle ever wind up going back to Naples, or does it go somewhere close?
It gets very close. It ends up right south of Naples and Paradise at what was then a Macayo's restaurant. It's gone now, but there's a parking lot. There's a business right at that intersection, and then just to the south is an open desert lot now, but there was a Macayo's restaurant. And it was at that location that it was collectively decided by the members of the surveillance team to take the vehicle down or do a felony car stop on the occupants of the vehicle in the parking lot of Macayo's.
And eventually the occupants removed.
Right, SWAT officers at gunpoint removed those occupants to the ground outside of the pickup truck.
And was Mr. Childers as well as Mr. Valerio identified as the two occupants of that
Yes, they
vehicle?
were.
Now let me talk, first of all, you wind up taking custody of Mr. Valerio at that point, is that correct?
Yes.
Let me talk about Mr. Childers. Does he wind up providing an interview to detectives investigating the case?
Yes.
And what does he explain about how it is Mr. Valerio wound up in his truck this day?
In brief, Mr. Childers' version is that his friend John Valerio came to his residence with a story that he had been shot at in his vehicle. He said that he needed to take a shower and get some fresh clothing, and that he asked for Mr. Childers to drive him back towards his residence so that he could retrieve an item.
And what items did you want to retrieve?
Mr. Childers tells us that Mr. Valerio wanted to go by way of the wash behind Naples Boulevard, come through the wash, in other words, not go directly to the residence, but walk through the wash and come up behind the building so that he could get into his apartment to retrieve a handgun from a washing machine where he had hidden it.
Now, you have Mr. Valerio in your custody at this point. What do you do with Mr. Valerio?
At that point, Mr. Valerio is taken into custody. The lead detectives in the case are, as I said, Bob Leonard and Detective Dillard. And they wanted him transported back to our homicide office, where we have small interview rooms that we take a suspect into, and he was detained there with me. I sat with him, awaiting those detectives to come to the detective bureau to do that interview.
Eventually, does there come a point in time when Dave Hatch arrives in the area where Mr. Valerio is being held?
Yes.
And describe for listeners and the jury what happens at that point.
Well, at some point after his responsibilities at the shooting scene, Detective Hatch leaves the Naples Street, returns to the detective bureau, where he is aware that I am sitting with Mr. Valerio. And Detective Hatch comes to the interview room where I am, and these have sliding doors, which I had the door ajar for fresh air to come in. And Detective Hatch reached his head in the door at that point, and I recognized him. And he looked at Mr. Valerio, and he used his hand and made a picture, or not a picture, but a motion with his hand like he had a gun, and pointed it at John Valerio. That was what Detective Hatch did.
And what was the response from Mr. Valerio to that?
Mr. Valerio, who had been really calm with me up until that point, got upset and said, I should have hit you, I tried to. And referring to the automobile and what he was doing with the vehicle on Naples.
And did that cause an argument then to ensue between Detective Hatch and Mr. Valerio?
It went back and forth for a couple of words, but Detective Hatch retreated from the doorway, and then Mr. Valerio calmed down.
Eventually, were you asked to transport Mr. Valerio to the Clark County Detention Center?
Yes.
And when you took Mr. Valerio to the Clark County Detention Center, sort of go through the process that it takes to put somebody in our jail.
When we go to the jail, depending upon the crime, we enter, as all police officers do with their suspects, and we go through a process where there's a little bit of paperwork, but then there's also some things that are relevant to the case. In this case, we wanted to get a blood sample from Mr. Valerio, and we also wanted to get a urine sample from Mr. Valerio for the obvious reasons regarding the officer-involved shooting, and also for the case in chief. And so I was responsible for collecting these blood and urine specimens. In the presence of the nurse that works in the jail, I witnessed the draw of the blood and the urine specimen being collected. And then I have a method that I impound those into a refrigerator at the jail so that they can be examined by forensics at a later time. During that process, I had a conversation with Mr. Valerio. He actually initiated it. He said that his back hurt, and he pulled his collar on his shirt away, and I could see that he had an injury on the back of his neck. And so then I wanted to see the rest of his skin on his body, and I asked him to remove his shirt. The reason I did that is because, believing he was the driver of the vehicle, I knew there could be forensic evidence relating to the gunshots that had occurred in close proximity to him as he drove the car near Detective Hatch. And so Mr. Valerio removed his shirt, and I could see that there was damage to his left side in the form of what we call stipple, which are little red pinpoint marks that I believe came from the glass of the car window. And also he had clearly a defect on the back of his neck that was round in shape, like one of the pellets of double-aught buck shotgun. It looked like it had glanced off and just made an abrasion on his skin. And so those were the things that I saw, and subsequently called for a crime scene investigator to come to the jail and document those photographically.
And did Kathy Atkins come to the jail
Yes.
and document those?
Yes, she did.
Mayor Bush?
You showed this to Mr. Erickson?
I have.
Okay, go ahead.
Detective, I'm showing you what's been marked as State's Exhibit number 40, 43 through 45. Ask you if you recognize those photographs.
Yes, I do.
What are they?
These are photographs of Mr. John Valerio at the Clark County Detention Center, taken at my direction by that crime scene investigator, Kathy Adkins. And they depict the damage that I was just talking about with regard to the red marks and the wound on the back of Mr. Valerio's neck.
And Judge, I would note that 40 was previously admitted in the prior proceedings, 43 through 45 are new, but I would offer 40 and 43 through 45.
Any objection to decide those previously stated?
No.
All right, 40 and 43, 44, and 45 will be admitted.
Start with 40. It's an identification photograph of Mr. Valerio, how he looked on October 3rd of 1986.
Yes.
And then we sort of talked to these. I'm going to go slightly in a different order. You said you noticed a defect on the back of his neck, and this is 44.
Yes. Here's a photograph of me at the jail with Mr. Valerio, and I believe that's my hand, I'm not sure, but there's the ruler, just like at autopsy, so that we could determine the size of the wound, near the wound, center of the neck, and it had a round shape to it, and it was enough to bleed, but not bleeding at that time.
And then 43, appears to be your hand with Kathy Atkins taking the photographs.
Yes.
And what are we looking at on the left side of his body?
Here is fragmentation of something, either gunshot powder residue, in this case, or glass, that had peppered the skin through the clothing of Mr. Valerio as the shot was fired at him in the front seat of the car.
And then 45 is a documentation of the similar type injury to his left arm.
Yes, he's holding the ruler for us on that occasion, and we're documenting more of that stipple, which looks to me like it has some dark coloration, which would be consistent with gunshot powder residue.
And the fact that it's on his left-hand side is consistent with the person driving that vehicle sort of laying down on his side to avoid the gunshots as he passes Detective Hatch firing into the car.
It's consistent with that. I mean, he's certainly on the driver's side of the vehicle.
So, once you have Mr. Valerio in custody, he's at the jail, do now people go back and process 432B, the apartment, as potentially the crime scene in this particular case?
Yes.
And have you had an opportunity to review the photographs of not only the shooting scene, but the interior of the apartment as well?
Yes.
And I'm going to show you what I believe has been admitted at the prior proceeding as state proposed exhibits 23 through, oops, nope. I have them backwards order. Right, 21 through 39. I'll briefly flip through those and tell me if you recognize, or those appear to be photographs taken by crime scene analysts, both at the apartment itself as well as the shooting scene involving Detective Hatch.
Yes, these are photographs I'm familiar with. They are the exterior and the interior of 432 apartment B on Naples. Some of them are photographs at night, and some of them are during the daytime. I don't know if that was a return trip or the investigation on those shootings sometimes lasts hours, and they may have been morning photographs. But they are all of the area surrounding 432 Naples apartment B.
Move to omit 21 through 40, which are the same, or 21 through 39, which are the same numbers as the guilt-based shooting.
Other than any objections previously stated, is there any further objections? All right, exhibits 21 through 39 will be admitted.
So let me start with 39. What is 39?
Okay, 39, as I just said, was associated with 432 Naples. Really, that's not where it's found. That's a photograph I had taken after I found the vehicle over on, in an apartment complex not far away from Naples. But that's John Valerio's vehicle. Here you can see the damage from the shotgun blast to the rear of the car. On either side of the trunk lock, we can see a pellet penetrated the body skin, left and right. And we see skip marks from the pellets up near the bottom of the rear windshield, and then the back windshield was taken out.
So it appears the car shot at, not only is there physical evidence on Mr. Valerio, but it appears to be his car as well that's got physical evidence on it to establish that's the car Dave had shot.
Right, that was located at 301 Sands in an apartment complex called Sunrise Villas.
So, just so the jury knows what these photographs are, when they're looking at them, I'm going to go back to the shooting scene photographs and start with 36, just so you can describe them for us. What are we looking at here?
Okay, here we have a nighttime shot of the detectives involved in the case and supervisors. Everybody comes out when there's an officer involved shooting, and they cluster up off to the side there. But the worker is the female that we see in the shot with the radio in her back pocket. She's responsible for the placement of those red cones, orange cones in the street. These cones are used by us to document the location of items of evidence that are pertinent to that shooting. In this case, they may be cartridge cases. I'm not familiar exactly what those two orange cones are. They may be acceleration marks on the blacktop that show where the vehicle was accelerating and the tires left some debris or black marks. And then we have a cluster of other cones further down, which in my opinion, or I'm sorry, in my experience, they are where the shooting occurred because they're so close together and there's a lot of debris left behind by a shotgun when it's discharged.
So let me flip the direction here, 37. That's the flip side of looking in the other direction of the picture we just looked at in 36.
Yes, that's correct.
And then if we go kind of zooming in on some of this,
Right. What we
this
see
white
here-
vehicle over here, why don't we start there?
Okay. So we see that white vehicle, and then in front of that white vehicle, we have these cones that appear, and they keep coming towards the forefront of the photograph. It would be depicting travel by the offender's vehicle or the suspect vehicle in this case. You see a lot of white debris in the street. In those days, they were putting road flares out, and those flares left behind all that ash on the street. We don't do that anymore. So that's what all that white stuff is in the street. Over here, the cones to the right, that would be the positioning of Detective Hatch's car and debris left behind in the form of cartridge cases when he would cycle the weapon after discharging the shotgun and then extract that expended round and then chamber another round. Well, those get extracted somewhere and they usually go out on the ground.
So now I'm going to jump back to the execution of the search warrant on October 4th of 1986 at 432B, Naples. And I'm going to start with exhibit number 21. What are we looking at?
Here we have a photograph. We're facing north. The front of the building is facing south. We're on Naples, and this is 432B, the right-hand side. You can see A is to the left. The doorway to the left. Well, it's actually a protrusion over by that vehicle frame that you see there.
And then you mentioned there was one as well, apparently, that was emitted from the nighttime in 0 to 2.
Right.
That's also 432B, is that correct?
Yes, the unit to the right.
And as you zoom in on, hard to see here, but a bunch of these little orange tags. Do you recognize what those orange tags are that aren't there on the first picture?
Yes.
And what is that?
These tags are put into place at the completion of a forensic examination of a location that we've usually obtained a search warrant for. Sometimes we have consent to search, other times we get a search warrant authorized by a judge to allow us to search a location. When the forensic work is done and the detectives decide that they've gotten everything that they need for their case, they leave the residence, and these seals are placed on the residence so that in the event they need to go back, they can show that the residence was never reopened again and that everything was left exactly the way they left it. So doors and windows are usually have this tape applied to them.
And then 23, just sort of another angle, sort of to the right side of 432B.
Right, here we have our photograph in the morning. I don't see the seals there on the window at that time, so it's obviously out of sequence. I don't know if that photograph was at a different time, but this is like the alley down the north, it would be the east side of 432B.
And then the photographs kind of go inside, and I'm going to start with 24 here for just a moment.
Okay.
First of all, in your experience, are those arrows there when the detectives first walked in the door with the search warrant?
No, of course not.
All right, what do the arrows represent?
At that time, arrows, these sticky arrows, were used to identify items of evidence that we wanted to collect and photograph because we thought they pertained to the crime that took place inside that particular room. Here we have arrows pointing in a downward direction, which mean that the detective and the crime scene investigator that located these items on the wall, they wanted to show some directionality, and in this case they were droplets of what appeared to be blood. So as the liquid would strike this object, which is the wall in this case, it would have some directionality, and that directionality was in a downward position. So they would try to put those arrows depicting that and then take this pullback shot. Consequently, there is a close-up shot of each one of those droplets as well.
Now, in 1986 was before the advent of at least the forensic use of DNA technology, is that correct?
Yes.
And other than being able to identify this as human blood, were the sample size big enough to do anything else with it?
At that time, they were not.
So as I sort of head from left to right in the room, State's Exhibit number 24. How about State's Exhibit number 25? As they sort of head towards the right, what are we looking at the bottom right-hand side of this photograph?
So we see the continuation of that long Venetian blind with more arrows that weren't in the previous picture. And on the bottom right is what appears to be a mattress on top of a box spring there in the same room.
And then this hanging dog can sort of orient us on where we are inside the room.
Yes, it's very helpful.
So then we move on to 26 as we turn right. What are we looking at?
Well, there's the dog, and we know that we're looking at the same window where the arrows were. And there's the corner of the bed that we saw with the green blanket on it. And the box spring and mattress are there. And they, of course, are of interest to our detectives who were at the scene because we believe that a crime's occurred inside that bedroom.
And then behind this, so sort of on the back right, that's the washing machine.
Yes.
And within that washing machine, what was located?
A 38 caliber short barreled revolver was found there.
And eventually was that revolver checked to see if they had any information about its registration information?
Yes, it was.
And what did the detectives learn?
The detective learned that at that time that weapon had been reported stolen, and its whereabouts were unknown until they located it in that washing machine.
And the owner of that particular firearm was a David Meisner, M-E-I-S-N-E-R, and he reported it stolen in 1985.
Yes.
So is that also the same washer that Brenda was looking for the sheets that allegedly came off, or the bedspread allegedly came off her bed?
I believe so.
And so then as we keep going to the right, State's Exhibit number 27. What are we looking at?
So here we don't have the dog for association in the photograph anymore, but we do know that there's the same bed. Now the headboard we're looking at blue up against the wall. We can see the back side of that washing machine, so we know we're looking at the same bed in the same bedroom. There's a small vanity with a mirror above it, and there's miscellaneous, what look like bedding, sheets, pillows, pillowcases on top of the bed.
And then lastly, for this room anyways, State's Exhibit number 28. That's just sort of almost completing the circle as we go around.
Exactly, so now we can see the right side of the headboard of the bed, with a small table next to the bed and a small lamp on it. And then into another room where the flooring changes from sort of a parquet wood floor to a vinyl product, and you see that couch and then the ironing board.
State's Exhibit number 30. As we keep going around, we're now back to the arrows with that picture, and now we're looking at the left side from where the first picture I showed you, Exhibit 21 is.
That's correct, and we also see in this photograph now we have arrows on the floor, depicting, as I had described earlier, more blood droplets.
And, State's Exhibit number 31. Do you recognize the individual depicted in that photograph?
Yes, I do. This is Detective Bob Leonard, one of the lead detectives in this case, and he is using his fingers to point out for the photograph what looks like blood on the mattress. The mattress clearly has been stood up at this point. As they were going through, the forensic investigators are going through the items on the bed first, and then once the bed is stripped, then they lift the bed, stand the bed up, look under it, and during that process, he identifies these two spots that he wanted photographs taken of.
I got it, Linda. And then, Judge, the prior proceeding, a close-up of 31, identified as 31A, was admitted. It's also marked for 31A for purposes of this proceeding. I would approve it.
And have you seen Mr. Erickson?
Yes, Your Honor, we have.
All right, any objection of the previous estate?
No.
Okay, 31A would be.
Now, you mentioned that there were some arrows on the floor, and I'm going to put up for you State's Exhibit number 32. What are we looking at?
So this is the floor inside the apartment that I call the parquet floor, if that's what it is, but I described it as sort of a wood floor. I think it's vinyl tiles, and that arrow was depicting a drop of blood that was located at the time, and for the purposes of the investigation of the crime scene diagram, it was also included with an arrow.
Now, while they had some limitations associated with DNA, they still had some ability to do some chemical processing and learn information that is not exactly visible to the naked eye. Is that fair?
Yes.
And Miss Gagliardo, when she described to the police coming home and finding the bed missing and looking for it, did she mention something about the floor?
Yes.
Or what she mentioned?
She indicated that there appeared to be some kind of smearing or some kind of cleaning that had taken place on the floor, which discolored near the side of the bed.
I'm not sure how great this photograph's going to come up, but I'm going to put for you State's Exhibit number 33. When they were done processing the scene initially, do they spray something that's called luminol?
Yes.
And in the course of your career, have you used luminol at scenes on a variety of occasions?
Yes, on a variety of occasions I have.
And I'm going to kind of zoom in on the floor and hope that this maybe has a better view. When they look at the photograph up close, they'll be able to see it. What is luminol and what does it do for you?
Luminol is a chemical that was found to reflect a fluorescent type of a light under absolute darkness in the presence of amino acids that we know are in blood. And so when, to the naked eye, in a well-lit room, no blood is present, we can darken the room and then spray this chemical in areas that we suspect there to be blood. And this is the type of reaction that you get in the presence of amino acids. Here it worked. The photography is difficult to see, but we can see that there was large amounts of blood in several locations on the floor that we couldn't see without the use of the chemical.
And when somebody, let's say, wipes it up enough so that their eye can't see it, that leaves behind enough of a trace amount of that amino acid that we can see blood that have been cleaned up, that's been there for a while.
Yes, actually it helps us determine a little bit more about what occurred in the crime scene, how busy it was, so to speak, and also it allows us the opportunity to maybe collect a piece of the floor for further examination that we would have overlooked without the chemical.
Now, during the course of this search of the apartment, did they find a couple of knives?
Yes.
Okay, sorry, I turned around and didn't realize you were drinking. And did they also find a blue jacket that they associated with Mr. Valerio?
Yes.
I'm gonna put up State's Exhibit number 35. What are we looking at here?
So here is the closet in that very apartment that we've been talking about, 432 Naples. We have a jacket, it looks to be a male's jacket. In the pocket of the jacket, I don't know if that's one of the crime scene investigators with a gloved hand or not, but whoever it is holding a book that was found inside the jacket pocket.
And that book was previously, well, the evidence envelope was previously admitted as State's Exhibit 70, and the book itself was 70A. It has been marked as 51 and 51A for purposes of this proceeding, I would offer.
All right, any objection to those stated, Mr. Harrison?
Yeah.
All right, 51, what is it being marked for this proceeding?
51 and 51A.
Those will be omitted.
So, now let's, that is way upside down. And I'm gonna go to B anyways. Alright, we're gonna have to go the old way. Adam, sir, can you put it on the overhead for me? So within 51A, there's some handwriting.
Yes.
I guess I should have brought my glasses up because it'd be a lot easier for me to see what I'm doing here. And it looks like the name filled in for this particular address book is John Valerio.
Yes, it says John Valerio on the top of that page.
And then where this paper clip is within here, there's an address for an Al Roxy and a phone number 386-8649.
Yes.
And remind us, is that phone number relevant to the investigation?
Yes, well, we saw the name Roxanne in the trick book, but we also saw the phone number 386-8649 associated with Kara Blackwell.
And during the course of the investigation, was there an exemplar taken of the known handwriting of Mr. Valerio?
Yes.
And did an individual by the name of Bill Lever, a forensic examiner, compare his handwriting and come to the conclusion that this writing was most probably John Valerio?
Yes.
In addition, within that blue jacket, was there a set of keys?
Yes.
And that, so a set of keys, which have been previously admitted as State's Exhibit number 53A, were ultimately identified by Summer, the 9-year-old daughter of Karen Blackwell, as the keys, her mother's keys.
That's correct.
And the car, when it was found, the keys were missing, correct?
That's correct.
So that's an item that appears to have been retained by the perpetrator.
Yeah, here's the keys to her car at Naples.
It is 12:42. This might be a good time for a break.
How much longer do you think we have?
20 minutes, half hour?
All right, let's go ahead and then take the break. All right, ladies and gentlemen, try to get back by about 1:45. I will make every effort to get us started off on time, to put in a full afternoon. As always, as I can't at the moment find my notes, do not talk to each other about the case or about anyone who has anything to do with it. Do not talk with anyone else about this case or about anyone who has anything to do with it. Do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it to me immediately by contacting the marshal. Do not read any news stories or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. Do not visit the scene of any events mentioned during the case or undertake any investigation, experimentation, or research on your own, including the use of any social media to discuss the case or the internet or other reference materials to any investigation or research. And do not begin to form or express any opinion on any subject connected with this case until it is finally submitted to you. We had a few sort of stops and starts this morning. I apologize for that, but we will push through this afternoon. So Have a great lunch. We'll see you soon.
All rise, you're ready to meet.
Not from the state, we're gonna finish Detective Vaccaro and call Nina Hollander, check with the clerk that everything we offered has been admitted and we anticipate resting. So Nina Hollander's ready to testimony, so I imagine we get through both of that and they can start in the morning.
So she's ready to testify.
Ready, she did.
A camera, and I have no idea where that camera came from.
Well, there was a media request.
There was?
Yeah.
When?
I don't know, prior to the start of this, sometime last week, I think. I don't remember the name. It's some sort of streaming media.
That's correct, there was a media request, and I asked them, it's certainly not our office, Mr. Vaccaro, if that was your concern.
It's a media request.
What about the media?
Huh?
If they have a camera, are they media?
Well, I mean, if they make a media request and say they're going to stream it as part of their news function, the state Supreme Court has broadly defined media. I mean, if you've got a particular concern about the...
I don't remember getting a media request.
You don't get the media request, it comes to me. It still has a copy of it.
Yes.
Give you a copy of it.
Yeah, true.
Sure.
And I will look and see if they were sent to my office, if they have been.
Thank you, Judge, we'll see you back here.
Oh, wait, anything else?
No, if only we're gonna finish it with Jimmy and then go to Holland, and that's it.
And I'm not trying to discourage any other instructions or picture issues or anything else that you can anticipate. I mean, again, I'm not trying to tell you not to do anything. I just want to do it now rather than with the jury
I
back.
think we're out of pictures at this point, Judge, so the picture issues has got to be solved.
All right.
What we can do it after the sun lunch. I don't need it for him, so I'll make the.
What do you need?
What do I need?
Yeah, what do you need?
I was gonna make the record of your ruling on not getting into the police report of Stubs.
Okay. All
Or
right.
you limited it, but we can do that at the end of the day.
Yeah, we can do that at the end of the day. Okay, all right.
Thank you. You might